May please, your lordship. My lord, I am praying for listing of this matter on next Monday, my lord.
What is the matter?
My lord, the matter PL, my lord, we paid for changing of road alignment, and on the earlier occasion, lordship has asked us to go through these decision, my lord. I got some decision.
Get it listed on Monday, Tuesday.
My lord, please.
My lord.
My lord, this matter may be listed on Tuesday for motion, my lord.
What is the matter, madam?
This is a review petition, my lord.
Order passed by?
Order by this division bench, my lord.
Very well.
In writ appeal, my lord.
Get it listed on Tuesday. It's a fresh matter.
Yes, my lord.
Okay.
No, please, my lord. My lord, an idea has been filed lordship yesterday, lordship. I beg to mention for listing lordship on tomorrow, lordship. My lord, I for execution of personal reference of the container number 3 and 6, lordship. On last day, lordship, whatever, lordship, my daughter was lordship in hospital, lordship. Matter was fixed on 19/7. Now, on that day, lordship, I could not appear, lordship.
So we have directed personal appearance.
Yes, my lord.
What do you want? You want exemption?
Yes, my lord. Yes, my lord.
Monday?
Obviously.
Daily list for orders, item 9.
Yes, please.
As per last order, my lord,
The registry has reported there were no more writ appeals in that matter.
yes.
All right. Now, what do we want to do?
I'm checking. As per last order, I have filed the correct new post title liner regarding the substitution of the response number 7. Response number 7, my lord.
Yes.
I have filed the new post.
Are you appearing in person, sir?
My lord.
Is it a matter wherein you are appearing in person?
No, my lord.
Your band is missing, gentlemen.
Sorry.
Pass over. Let him.
Time being.
We are passing it over. Come properly with proper attire.
Item number 10.
Meet me, Lord. Lordship, this matter is with regard to me, Lord, the construction of the Silchar Harangaja Road.
What is the status report? Have the respondents filed a status?
No, my lord. As on the
Last date, we directed the names of the standing council would be mentioned. Yes. They are there. Where are the standing council concerned? Pass over.
Lord, much obliged.
Item number 11 and 12.
Yes.
My lord, the contractual employees were initially employees under the DRDA. That particular department has now been absorbed by the PNRD. So now the authority that is overseeing the entire state of affairs is the commissioner. And at the district level, it is the CEO, my lord, the executive officer. So all the records that are pertaining to this particular appellant in this particular case are under the custody of the CEO. We have got the records pertaining to one matter, my lord, Abhishek Bhattacharya, they are taken up together.
Okay.
However, as far as Ramchandra Paul is considered, my lord, the records are still awaiting. My lord, take up Abhishek Bhattacharya.
So you want the matters to be taken up in isolation, separately? All right.
Some time, my lord.
Need time.
My lord, the documents I have annexed, my lord, regarding the appointment letter and the contractual agreement, they did not dispute it before the single bench, my lord. Whether.
But we had directed them to keep the contract available.
Yes, my lord.
So we need to see that.
So, my lord, the matter may be, my lord, segregated and the item number 12 may be taken up, if you like.
Why segregation? What is happening? Otherwise, it's a contractual appointment.
Delaying, my lord, matter is.
And council, Mr. Appearing for the respondent department.
PNRD department.
PNRD prays for and is granted further opportunity of 3 weeks to keep the record available. List on 13th September.
Item number 9.
No. Yes, what is there in 9?
Yes.
No other rate appeal has been preferred.
Yes, let's
So
find out information.
We'll list it for admission then.
All
Officers reported that no other writ appeal. No writ appeal was preferred against the judgment dated 26/2017. And furthermore, no other writ appeal has been preferred against the judgment impugned in this writ appeal. Hence, list the writ appeal for admission on 28th, 29th.
Item number 13.
Yes, please.
May please lordship, my lord, we are appearing through VC.
Yes, so now
Well,
what is the
am I-
difficulty? Once you are appearing through VC, your challenge
ma'am.
that the files should not be transferred is immaterial. You can argue
Yes.
from there is no difficulty. You have cited a difficulty that it is very difficult for you to come to Guwahati and argue the matter. We have given you the facility of VC. Argue through VC, there is no difficulty. The files can be listed now. We sooner or later, we'll get a system wherein the files can be heard by anyone, anywhere in the country.
My lord, that is true. But
Then-
then, my lord, here the main question is,
Yes.
my lord, here this petition is
Any-
a test.
You see, gentlemen,
Yes.
any matter can be heard in the principal seat. For transferring a matter to another bench, of course, some other considerations may be in vogue. But so far as the principal seat is concerned, it has got the jurisdiction to hear any matter within the jurisdiction of the Guwahati High Court. That is what the
My
law
lord,
is.
Yes, my lord, may I make my submissions, my lord?
Yes, sure.
My lord, this petition is basically to test the jurisdiction, independence and authority of the Itanagar Permanent Bench of the Guwahati High Court. My lord, in other words, my lord, the nature, competence, jurisdiction, functions and character of the Itanagar bench is to be looked into. And another issue is, my lord, whether the territorial jurisdiction, once determined and bestowed under presidential order, can be altered or taken away or confer that jurisdiction to another. Thirdly, my lord,
You,
Whether
before
the Itanagar
Mr. Patin, before
yes, my
we
lord.
we take up your issues. First, let
Yes,
us
ma'am.
know what is the jurisdiction of the Guwahati High Court as such.
My lord, under
On what
two-
states does the Guwahati High Court exercise jurisdiction?
under Article 331, the Guwahati High Court is a common high court
So
of the
it,
Constitution. My
that
lord,
presupposes
therefore-
that the Guwahati High Court has jurisdiction
Yes, my lord.
to exercise its powers in all of the 4 states, including
my lord.
Assam, Arunachal, Nagaland, and Mizoram, right?
Yes, my lord.
Okay, then
But my lord, the territorial bifurcation that has been made
that
under
has
the
been done.
presidential,
That is for
under the presidential
convenience.
order.
That is just for convenience. Supposing there is a situation that there is no judge, no division bench can be formed in Itanagar. Would you allow your litigants to remain remediless? Then all right, if
No, my lord.
your argument is to be
My lord,
accepted.
My lord, in fact, that is our argument. When the Itanagar Permanent Bench is functioning, both the division bench and the single bench are
So
functioning.
every other day, the Chief Justice would be required to take stock of the things. Today, who are available? Is it possible to hear the appeal today? Whether there is any recusal request? Every day we will have to take a fresh decision, right? That is your argument.
No, my lord, that is not my argument. My lord,
Then,
rosters are prepared and the registry knows, my lord.
who is the
So,
master of the
Malad,
roster? Please let us know.
My lord, as far as master of roster is concerned, my lord, my respectful submission would be,
Yes.
my lord, the Chief Justice of Guwahati High Court. When
Then the
functions
assignment,
as the master of roles,
assignment of
master
a
of rosters.
particular matter, Mr. Patin, assignment of a particular matter to a particular bench In whose domain is that?
To my respectful submission, the territorial, that would amount to altering the territorial jurisdiction
Okay.
of the respective benches.
So then you will have a remedy of challenging the order of the division bench at principal seat by alleging that it does not have jurisdiction to entertain the matter, right? Why not test the order on that and will?
We have filed this case in the Guwahati High Court, Itanagar Permanent Bench. This was transferred, and
Yes.
this has come up before your lordship on the
Yes.
basis of a notification that at 14 August, recent notification.
Yes.
Now, my lord, our submission is that the territorial jurisdiction that is bestowed under the presidential order
Yes.
and the notification cannot be altered in this manner, my lord. We are sorry, my lord. We seems to be disrespecting your lordship's.
No, not at all, Mr.
order,
Patil.
but then, my lord,
Don't even think of it for a moment. This is a
Yes,
legal
ma'am.
argument you are advancing. We are
Yes, ma'am.
absolutely not at all irritated, annoyed in any manner. This is your
Yes, ma'am.
right. This is your right. But
We're-
we are putting you queries. You have to answer
Yes,
those.
ma'am.
Don't
ma'am.
feel that we are feeling offended. Don't even feel that for a moment. Don't worry.
We are
We are taking your arguments in the positive frame.
Yes,
Mindful,
ma'am.
don't worry. Yes. So tell us now, do you have any
Uh,
law on this aspect? You know, Mr.
Yes,
Patil,
my lord.
this,
Yes,
yes,
my
what is the
lord.
law? Supreme Court
my
judgment.
lord, may I just continue, my lord? My lord, the Itanagar Permanent Bench was established in 2000 by notification that at 18/7/2000, 2000. My lord, it is in our High Court rules, Appendix
Yes.
19, my lord, page 349.
Hmm.
Now, my lord, Arunachal Pradesh Statute Act is an act passed by the parliament, and Arunachal Pradesh is an state within the meaning of Article 1, 2, and 3 of the Constitution of India,
Yes.
and hence it is a separate, independent state with full power and authority bestowed to a state under the
Hmm.
Constitution of India and the laws framed thereunder.
Yes.
My lord, Article 214 of the Constitutions
Hmm.
mandates that every state shall have a high court. But then, my lord, since there are some difficulties, Article 331 ordained for establishment of a common high court. And
Hmm.
accordingly, my lord, our Guwahati High Court is within the purview of Article 231. Now, my
Yes.
lord, therefore, the authority of the Eastern Arunachal Pradesh under the Act has to be homogeneously read
Hmm.
in terms of Article 1, 2, and 3 of the Constitution.
Yes.
Now, my lord, under this broad spectrum, and also, my lord, my initial submissions that I have basically three submissions.
Hmm.
My lord, first is to test the jurisdiction, independence, and authority of the Itanagar Permanent Bench,
Hmm.
and the functions and character. Second is, my lord, whether the territorial jurisdictions once determined and bestowed under the presidential order can be altered or taken away or confer that jurisdiction to another.
Yes.
Thirdly, my lord, whether the Itanagar Permanent Bench, when it is sitting here, will function as a separate high court for the state of Arunachal Pradesh
Yes.
and for the cause that has arisen
So,
at
Patil,
and within the
Patil,
state of Arunachal Pradesh.
Mr. Patil,
Yes,
before
my
you
lord.
proceed further, so are you proposing that a situation may be created that for months together, the people of Arunachal Pradesh may be deprived of the right to file an appeal? Do you have any such proposition? If your proposition is accepted, and supposing a situation is created, then and we decide that the Guwahati High Court principal bench has no jurisdiction, principal seat has no jurisdiction to entertain a matter of Itanagar, then there may be a situation that for months together, the litigants may be deprived of availing a right of filing appeal. Do you countenance that situation?
No, my lord. In fact, my lord, there has been situations where initially when the Itanagar permanent bench
Patil,
were established, but we're not functioning. My lord,
question here is-
I'm just
Mr. Patil,
coming
just
to your
hold on,
lordship's.
please, hold on. The pertinent
ma'am.
question we are posing to you is that in case this argument of jurisdiction is decided as per your submission, right? That the principal seat does not have any jurisdiction to entertain a matter which arises in Arunachal Pradesh, then what would be the situation wherein the Itanagar bench is not able to take up an appeal? What would be the situation? Tell us, please.
My lord, my respectful submission would be that we are not saying that if any such circumstances arises,
The
then
simple question is, if the issue of jurisdiction is decided for once and for all, then whether the Chief Justice would be left with the discretion to transfer any matter in a particular situation. Give answer to that.
my lord, for that, let us go to the language of the notification, my lord. Your
Yes.
lordship may kindly 349, page 349.
Page,
Yes, may I read, my lord?
from where are you
In
reading?
excess, 349, my lord.
That
Guwahati High Court
Guwahati
rules,
High
my lord.
Court,
So,
rules
Yes,
2022, page 349. Lord.
just hold on, let us get the rules.
349.
Sure.
Here are. दीजिए.
You've got it.
Yes.
May I read, my lord?
Hmm.
In exercise, Guwahati High Court establishment of permanent bench at Arunachal Pradesh Order 2000, notification number such and such. In
Yes.
exercise of power conferred by subsection 2 of section 24 of the State of Arunachal Pradesh Act, read with subsection 2 of section 31 of the Northeastern Areas Reorganization Act 1971, the President, after consultation with the Chief Justice of the Guwahati High Court and the Governor of Arunachal Pradesh, is pleased to make the following orders. 1. So title, this order may be called the Guwahati High Court Establishment of a Permanent Bench at Itanagar, Order 2000. It shall come into force on the 12th day of August 2000. The paragraph 2, establishment of a permanent bench of the Guwahati High Court at Itanagar. There shall be established a permanent bench of the Guwahati High Court at Itanagar, and such judges of the Guwahati High Court, being not less than 1 in number, as the Chief Justice of that High Court may from time to time nominate, shall sit at Itanagar in order to exercise the jurisdiction and powers for the time being vested in the Guwahati High Court in respect of cases arising in the state of Arunachal Pradesh. Now, there is a proviso, my lord. Provided that the Chief Justice of that High Court may, in his discretion, order that any case or class of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati. Now, my lord, the main purpose of the paragraph 2 of this notification is that the Itanagar Permanent Bench shall exercise all the powers and functions bestowed to the Guwahati High Court for the purpose of the cases arising in the state of Arunachal Pradesh. However, there is a proviso. In that case, supposing, as your lordship has pointed out, supposing there is some difficulty in holding the courts at Itanagar, that in that case, usually earlier, that's why I was saying, earlier the sitting of the benches in Itanagar was not regular, not like these days. And in such situations, what we used to do is,
Patil, that is why we have, that is
write
why
a
we have-
letter.
Mr. Patil, that is why, Mr. Patil, that is why we have put you the query that if you get the issue of jurisdiction decided against the domain of the Chief Justice to direct any matter to be heard in Guwahati, then what would happen to the proviso?
My respectful submission is, my lord, proviso, my lord, it is only to remove a difficulty.
This,
Only for the purpose of
this
remove a
proviso
difficulty.
doesn't
But
say so,
this
sir.
proviso
Proviso doesn't
can-
say so, sir. Proviso doesn't say so. It gives an absolute
my-
discretion. Absolute discretion.
my respectful
It-
submission
it
is,
is
my lord,
not-
this
it is
absolute
not-
discretion.
It does not begin with a heading. in order to remove difficulties. This is a discretion given to the Chief Justice. And
my lord,
you are asking
my
us to interfere in that discretion.
lord, my legal submissions would be, my lord, the main provisions is at the
Proviso
section 2.
supersede.
Section
Your
2.
argument is
This is the
proviso
main
does not
intent and
supersede.
purpose.
Yes.
The main intent and purpose
Hmm.
is at paragraph 2, that is to exercise the jurisdiction and powers for time being vested in the Guwahati High Court in respect of cases arising in the state of Arunachal Pradesh.
Yes.
Now, my lord, my limited understanding is that the proviso, this is the main intent of the act.
Yes.
This proviso cannot be utilized to defeat the main intent of the act.
Mr. Patin, this proviso has to be read with the observations made by Honorable Supreme Court in the matter
Yes.
of master of roster matter, right?
Yes.
So
Yeah.
those
Gandhi.
observations taken
My lord,
together with the
my
proviso,
lord, as far
leave the
as
Chief
far
Justice
as
that-
this
you have to have, Mr. Patin, you have to have faith in your Chief Justice. That is what primary
absolutely, my lord,
observation
we
is.
have the no such ill
What
feeling
is,
or
all right, tell
it's
us.
not that
Mr.
we are
Patin,
we don't respect
tell-
our
Mr. Patin,
Chief
Mr.
Justice.
Patin, tell us,
Yes.
what is the percentage of matters which are being transferred to Guwahati out of the total number of cases being
I
listed
think, my lord, it is about 86 cases has been transferred, and
in
others
all,
I do
in
not
all
know.
till date, in all till date, right?
That figure, my lord, I'm sorry, I don't have.
You
figure.
you have to be prepared with that figure also. So
Hmm.
if it is a minuscule percentage and the Chief Justice has exercised the discretion, the Chief Justice is not supposed to make the reasons for exercising the discretion public. It's an order on the administrative side.
No, my lord, in that situations,
Yes.
since the territorial jurisdiction and other things are there, my lord, and the main issue,
Yes.
and then
What is the law? All right. Let us go to
proviso.
the law on the
My
point.
lord, may I just take your lordship to 2005 3 GLT page 1.
2005 volume 3 GLT page 1.
Yes. My lord, paragraph 36 to 38, my
Let
lord.
us-
I'll read
let
from
us get the
36
book.
to 38, my lord.
Let us get the book. Just give us.
I had given the list of books, my lord, this morning.
Yes, yes. We are having it. Yes.
Yeah. 36 from 36, my lord.
Hmm.
May I read, my lord? Our quest for an answer to question as to what the territorial limits of the jurisdiction of the permanent bench at Shillong are bring us to the notification dated 4/2/2005. My lord, Shillong and this were all once together, and then same language except the placing of words.
Hmm.
Whereby permanent bench Common High Court came to be established at Shillong. Paragraph 2 of this notification states, in no certain words, that the permanent bench established at Shillong shall sit at Shillong in order to exercise jurisdiction and powers vested in the Guwahati High Court in respect of the cases arising in the state of Meghalaya. This clearly shows that the Shillong bench can exercise jurisdiction and powers which were available to the Common High Court, but the exercise of such power will be in respect of only those cases which arise in the state of Meghalaya. In the light of what Article 226(2) conveys, it becomes abundantly clear that the expression, quote unquote, in respect of cases arising in the state of Meghalaya, occurring in a notification dated 4/4/1995 will mean the cases wherein the cause of action has arisen, wholly or in part, within the state of Meghalaya. It logically follows, therefore, that if no cause of action has arisen in a given case within the state of Meghalaya, the permanent bench at Shillong cannot exercise jurisdiction in respect of such a matter. 37. Referring to the proviso to paragraph 2 of the notification dated 4/2/1995, aforementioned, which reads, provided that the Chief Justice of the High Court may, in his discretion, order that any case or class of cases arising in the state of Meghalaya shall be heard at Guwahati, Mr. V.K. Jindal has submitted, as already mentioned here in above, that the proviso to paragraph 2 of the said notification
Yes.
shows that the Chief Justice of the High Court may, in his discretion, order that any case or class of cases arising in the state of Meghalaya shall be heard at Guwahati, and this in turn means, according to Mr. Jindal, that High Court sitting at Shillong bench cannot return the present writ petition to the petitioner with direction to present it before the Court of Competent Jurisdiction. For it is the Chief Justice who can direct that the writ petition be returned for being presented at the appropriate bench. There is, to our mind, inherent fallacy in the submissions so made by Mr. Jindal. What needs to be borne in mind is that it is a cardinal rule of interpretation that a proviso to a particular provisions of a statute only embraces the field which is covered in the main provisions. It carves out an exception to the main provisions to which it has been enacted. The proper functions of a proviso lays down the effects code in Tribobandas, Haribai, Thamboli versus Gujarat Revenue Tribunals and others reported in such and such, is to accept and deal with a case which otherwise falls within the general language of the main enactment, and its effect has to be kept confined to that case only. Where the language of the main enactment is explicit and unambiguous, reminds the Supreme Court in Tribobandas Haribai Thamboli case, the proviso can have no repercussion on the interpretation of the main enactment so as to exclude from it by implication what clearly falls within its express terms. The scope of the proviso, therefore, is to carve out an exception to the main enactment, and it is excludes something which otherwise would have been within the rule. It has to operate in the same field, and if the language of the main enactment is clear, the proviso cannot be torn apart from the main enactment, nor can it be used to nullify by implications what the enactment clearly says, nor said it not the real object of the main enactment. Para 38, if on a fair construction, the principal provisions is clear, a proviso cannot expand or limit it. Sometimes a proviso is engrafted by a apprehensive draftsman to remove possible doubts, to make matters plain, to light up ambiguous edge. In Dwarka Prasad versus Dwarkadas Saraf, Air 1966, the Apex Court, while dealing with the scope of a proviso, laid down as follows. The law is right. A proviso must be limited to the subject matter of the enacting clause. It is settled rule of construction that the proviso must prima facie be read and considered in relation to the principal matter to which it is a proviso. It is not a separate or independent enactment. Words are dependent on the principal enacting words, to which they are taken as a proviso. They cannot be read as divorced from their context. If the rule of construction is that prima facie a proviso should be limited in its operation to the subject matter of the enacting clause, the stand we have taken is sound. To expand the enacting clause inflated by the proviso, since against fundamental rule of construction that the proviso must be considered in relation to the principal matter to which it stands as a proviso. A proviso ordinarily is but a proviso, although the golden rule is to read the whole section, inclusive of the proviso, in such manner that may mutually throw light on each other and result in a harmonious constructions. In view of this, my respectful submission is that this proviso can, there is no dispute that there is no proviso. And the Honorable Chief Justice has the discretion, but that discretion is not an open-ended discretion, my lord. It is subject to the facts and situations of the case. Supposing if a case is cannot be taken up.
Once that argument falls from your mouth, have you at all alleged in your writ petition that any particular order of transfer was not made by due diligence or without considering the peculiar facts of that case, which has been transferred? So if unless there is any such averment, it has there's a presumption that the discretion conferred upon the Chief Justice by the proviso has been excised in the correct light, in the view of the requirement of the situation.
With great respect,
Yes.
While drafting, we understand our relationship with the court. We are also we have to have certain decorum.
Nothing
So,
of
my lord,
funding in your, Mr.
this,
Mr. Patel,
this
just-
vote, I
Mr.
did not
Patel.
put it in the
No, no, no. No,
written
we
form, but then, my lord,
we are not at all, we make it clear that we are not at all, not in the least offended or even in any manner uh, prejudiced by the averments made in your petition or by your arguments. But the question is that when the fact that the Chief Justice has the discretion to transfer a particular case cannot be questioned, then unless you are able to make out a case that a particular case, particular matter has been transferred, we put your query, what is the percentage of cases till date transferred from Arunachal from 2013 to 2023? You say 86. So 10 years, 86 cases. Now, unless you are able to make out a case that the discretion has been excised without application of mind or without there being any need to do so, whether this general proposition can be considered
yes,
as holding the field.
my lord, my way I'm saying is, my lord,
Hmm.
these writ petitions, in entire writ petitions,
Hmm.
the course of action arose only.
That
in the
is
Eastern
why
Arunachal
the
Pradesh.
judgment you
Malad-
cite, Mr. Patin, the judgment
Malad.
you cited deals with cause of action. There's no dispute about it. And now with the virtual hearings being allowed, so many things have changed. There is a sea change in the entire system. This is a dynamic process.
Malad,
Now,
my
Odisha High Court,
another ground,
Mr.
another
Patin,
ground of my
Odisha, just
submission.
will let you know, just hold on. Odisha High
Yes,
Court
Malad.
has
Yes.
established virtual benches in various districts. Rajasthan High Court has recently, Rajasthan, there is a proposal to confer jurisdiction to Bikaner without there being a bench. So now all these things, now the scenario is changing very fast. You'll not be even able to understand how the scenes change with the advent of technology. So the main difficulty which you are facing is, you see, the judges will be from the Guwahati High Court, no difficulty. The lawyers, the difficulty being faced by the lawyers, that we are being made to travel to Guwahati, that is no longer there because you are arguing such an important matter sitting at Itanagar comfortably in your chamber. We are hearing you without any difficulty. We must appreciate that the connection quality is much better than many times we get the connections from Delhi even. There is
Yes,
no
sir.
break, there is no interruption. So we must appreciate that Arunachal is also coming forward with good internet quality, that there is a seamless transmission of signals. So we appreciate. So what is the difficulty? You are arguing before the Court of the Chief Justice. What is the difficulty in that? The scenario has changed, Mr. Patin. You have to be conscious of that. There is
My lord,
nothing,
we are
nothing,
grateful, my lord.
nothing adverse to the Itanagar bench when a matter is transferred. You rest assured that there are some reasons for which and very specific reasons for which the matters have to be transferred. If a general proposition is laid down and no exception, the exceptional powers are not left with the Chief Justice, we tell you, the situation will come that you will not be able to avail the right of appeal for months together. Whether you are prepared, then we will say, all right, Arunachal, the matter is, the jurisdiction issue is there. We will not transfer anything to Guwahati High Court. Let the bench excise jurisdiction. Do you want such a situation to be there? Therein,
No,
then
my
what
lord,
is the test? What is the test that the discretion has been excised with utmost care and caution? If that is the very exercise of discretion is put to question.
Exactly, my lord. Exactly, my lord. May I just narrate, my lord, the sequence? Now, my lord, before transferring all these cases,
Which case?
none of the parties, I'm,
Yes.
my lord, I'm submitting, my lord, none of the parties has sought for the transfer.
Yes.
In fact, NSPC had filed a writ petition which is pending 5402/2020.
Yes.
It was the registry of the Assam, Guwahati High Court had also put a note that neither the Assam state of Assam is a party, nor any of the officials of the Assam is a party.
Yes.
So with that note, that despite that, it was filed, and therefore the council of the NSPC was the first one to file an application seeking transfer of that WPC 5402. Now, I do not know, that was rejected, and in that application, it was mentioned that some cases of the same NSPC matters are
Hmm.
pending in the Itanagar Permanent Bench.
Yes.
And the Chief Justice then, Honorable Chief Justice, he ordered that that let the other cases pending in Itanagar be called for. Now, my respectful submission is that that manner of exercising the discretion.
That is a decision taken for ensuring uniformity in action.
No,
See, the principal seat takes a different view and the bench takes a different view. Would that be a happy situation? Would that be acceptable to the litigants?
No, my lord, as I have submitted, my lord, no one had sought for transfer of this case from Itanagar to Guwahati.
Understood. You yourself say some matters were pending in the High Court at Guwahati, some matters were pending in the Itanagar. Then the Chief Justice directed that let the matters be listed together in the principal seat. All right. Now, let's hear Mr. Tara. What does he have to say? Association. You switch on your mic, Mr. Tara.
I have some more point to discuss on the territorial jurisdiction, my lord. I have a citations also, my lord. I'll come back, my lord.
Please do. Please go ahead.
My lord, with great.
Just hold on, Mr. Tara.
privilege-
Mr. Tara, hold on. Mr.
Yeah.
Patin has some citations to present. Let us see.
Oh, yes, my lord.
Hmm.
My lord, 2001 to SCC, my lord.
Yes.
294.
Hmm.
My lord, I'll come straight to paragraph 9 onwards, my lord.
Hmm.
At page 301, my lord.
Yes.
Paragraph 9, 10, and 11.
Hmm. Yes.
My lord, this is a case within the state of Rajasthan.
Yes.
Main principal seat is in Jodhpur,
Yes, that's right.
but then they have established a
Yes.
bench at Jaipur.
Hmm.
Now, my lord, the notification of that also is the same, my lord, except the placing of the votes.
Hmm.
Now, my lord, may I read, my lord?
Yes.
From 9, my lord. The presidential order having established a permanent bench of the High Court of Rajasthan at Jaipur and having appointed the minimum number of judges as would sit at Jaipur, proceeded to declare that the permanent bench seat at Jaipur shall exercise the jurisdiction and power for the time being vested in the High Court in respect of cases arising in the districts, 11 in numbers, as mentioned therein. A discretionary power jurisdiction is also conferred on the Chief Justice of the High Court to order that any case or class of cases arising in any district forming part of the territorial jurisdiction of the permanent bench at Jaipur shall be heard at Jodhpur principal seat. The presidential order is clear. The jurisdiction allocated to the permanent bench at Jaipur is by reference to territory covered by the 11 specific districts. The proviso appended to para 2 of the presidential order speaks at any case or class of cases, but therefrom to a power in the Chief Justice to define course of action cannot be spelled out.
So there is no
Then
dispute.
the nature and extent of power conferred.
This deals with the defining of the cause of action. There is no dispute about that. The Chief Justice has no power to define a cause of action. The power which has been given, the discretion which has been given, is only to transfer a particular case or a class of cases to the principal seat or vice versa. The situation is that even vice versa is being directed in Rajasthan. When there is a bunch of matters, the entire bunch is either transferred to Jaipur or to Jodhpur. That is to facilitate commonality of the decision-making process. Nothing beyond that. No one is questioning your argument regarding cause of action or the territorial jurisdiction. The discretion is in a given set of circumstances when there is eminent need to transfer a particular case or class of cases. Had it been the situation that the Chief Justice passes a general order, all writ appeals to be listed before Guwahati High Court, you would have been right. It's not that order. It's a particular case which has been directed to be transferred. That power you can't take away. Neither the judgment says so.
Yes.
This order doesn't change the cause of action or territorial jurisdiction. There's only a matter wherein the Chief Justice has exercised discretion, saying that the matter is required to be heard, at the Guwahati High Court principal seat. That's all. Nothing beyond that. If we incorporate in this setup that the transfer of a case means transfer of jurisdiction, then there will be a situation wherein we will not be able to exercise that discretionary power by virtue of proviso. Carry on.
That is precisely one of the questions that I have raised is the territorial jurisdiction.
Yes.
Now, Malad, the paragraph 10 and 11, I'll read, Malad, because this
Yes.
is very, very pertinent.
Carry on.
The nature and extent of power conferred on the president by section 51 of the act came up for consideration of this court in state of Maharashtra and Narayan Paranik. It was held such and such 25. It is clear upon the terms of section 51 of the act that undoubtedly the president has the power under section 1 to appoint the principal seat of the high court for a new state. Likewise, the power of the president under subsection 2 thereof, after consultation with the governor of a new state and the chief justice of the high court for that state, pertains to the establishment of a permanent bench or benches of the high court, of that high court, of a new state, or at one or more places within the state other than the place where the principal seat of high court is located, and for any matter connected therewith, clearly confer power on the president to define the territorial jurisdiction of the permanent bench in relation to the principal seat, as also for the conferment of exclusive jurisdiction to such permanent bench to hear cases arising in districts falling within its jurisdiction. The creation of a permanent bench under section 2 of section 51 of the act must therefore bring about a territorial bifurcation of the high court. 11. The establishment of a permanent bench at Jaipur and defining its territorial jurisdiction brought out bifurcation of the state of Rajasthan into two for the purpose of division of territorial jurisdiction of the high court between the principal seat and the permanent bench. The chief justice of the state cannot, therefore, artificially or indirectly take away the jurisdiction belonging to one and confer it on the other, conferring a discretion on the chief justice to order any case or class of cases arising in any district within the territorial jurisdiction of permanent bench at Jaipur shall be heard at Jodhpur, cannot spell out a power to define where the course of action shall be deemed to have arisen in the writ case. So, my respectful submission is that just the manner in which this case has been transferred, it would hit the territorial jurisdiction issue.
Mr. Patil, your answer lies in para 18, wherein this power has been recognized. There is no, that is why we are again and again telling you, there is no general order, general administrative order that this nature of cases or cases arising from such and such district will be heard at Guwahati. There is only specific cases which have been transferred. Come to para 18.
Yes.
The purpose of the presidential order, page 305, is to carve out and define territorial jurisdiction between the principal seat at Jodhpur and the permanent bench at Jodhpur. The cases are to be heard accordingly, unless the Chief Justice may exercise in his discretion the power vested in him by proviso to so and so. So that power has been recognized by Supreme Court. Where is the question now of questioning that power? That's all.
My response submission is still, since course of action is also a consideration in this case. There are the partly or wholly, where in such situations, the discretionary power cannot be
So now, then
exercised
Mr. Patil,
to
now
defeat
we
the
stop
main
you here.
purpose of
Mr. Patil,
the
now we stop
paragraph
you
2.
here. Now we stop you here. Tell us in your pleadings which part of the discretion has wrongly been exercised. Tell us in particular matter. And why the discretion has been, why as per you, the discretion was not properly exercised. Let us know now.
In my petitions, I have clearly stated that no one has sought for, the litigants.
Yes,
they
is
were
it required?
surprised.
Is it required? Is it required that the transfer should be made only on an application? Does it require that the transfer should be preceded by an opportunity of hearing? No.
Yes, Malad.
No, it's not required. All right. Thank you. Yes, Mr. Tara.
after patiently listening to the argument advanced by Pertin sir and the question that has fallen from my lord, just to be on the substantial interpretation of Article 231 and the 55th Constitutional Amendment Act 1987 in respect of Arunachal Pradesh. And pursuant there to this notification, my lord, at 349. After giving a certain thought process, my lord, I'm forced to recall the approaches that is adopted to interpret such kind of constitutional arguments, my lord. The first, my lord, is aware that traditional or the historical approach, my lord. Then second is the textual argument, my lord. The third is a doctrinal argument. In doctrinal argument, my lord has referred to the paragraph 18 of 2001 to SSC 294 that now, my lord, it is finally rest with the structural argument, my lord, structural argument. Now, my lord, these are all well-known methods of interpreting the constitutional arguments. In this case, whatever approach my lordship may adopt, the end result will be the same. Here, my lord, I am going to urge, my lord, two counts in a chronological order. Firstly, on a question has fallen from my lord, who is the master of the roster, my lord? My lord, it is no more res integra that Honorable Chief Justice is the master of the roster. And my lord will only refer to Santi Bhushan, the apex court judgment, Santi Bhushan versus the Union of India, no? That is 2018-8 SSC, page 391, Lord, paragraph 41. Lord. There's no more res integra that Honorable Chief Justice is the master of the roster. Now, having urged, my lord, it is my understanding of the scheme of this case, my lord, is that there is one notification, perhaps, my lord, will kindly come to that. There is a order number 41, my lord. Order number 41, date 26/10/2005.
Yes, please. Yes. Page number.
2005.
That is at page number.
It is not, it is a notification, order number 41.
It's, have you placed it on record, please?
It was placed on the last.
Yes, in the previous bench it was there. My lord, has it, my lord?
Just a moment, Mr. Tara. Just.
Sure. Yeah. My lord, this order number 41, order dated 26/10/2005, which reads, my lord,
Yes.
in supersession of all the earlier orders issued in his behalf, it is hereby directed that all the cases pertaining to the permanent benches of Guwahati High Court, namely Kohima, Nagaland, Shillong, Meghalaya, Imphal, Manipur, Itanagar, Tripura, Aizawl, Mizoram, and Itanagar, Arunachal Pradesh, whether filed at earlier point of time or to be filed in future at the principal seat for absence of appropriate bench at the outlying benches shall stand transferred to the respective benches of the High Court immediately after completion of motion and or admission. Lord, My respectful submission is on the structural submission, my lord. Pursuant to this notification at page 349, my lord, then this particular order has come. And this is still in existence, my lord.
Yes.
In view of this order, my lord, I can only urge my lord to give a rational thought process as to whether the cases transferred from Itanagar bench to principal seat should still be continue to be adjudicated by my lord in principal bench.
Yes. Very good. Okay. Thank you. Yes.
Yes. And secondly, my lord, although that authority, my lord, I have not placed it, my lord.
No, you
The-
please give out the citation. We'll ask the court master to take it out. Give us the
Yeah,
citation.
my lord, I will not place a citation, but on a rationality of law, my lord, I'll
Yes.
put across one point, my lord. Now, in a legal parlance, my lord, it has always been urged and pleaded in the bar that justice is not only done, but seem to be done, my lord.
Should appear to have been done.
It should appear to have been done, my lord.
Yes.
Please, my lord, for a correction, my lord. In that view of the matter, my lord, shall we not give a proper rational thought process to ensure to the fact that the interest of the litigant should be seen first, my lord? My lord, kindly try to recall that Bombay-based bakery case, my lord. There, the first principle of law was settled by the Honorable Apex Court while dealing with the territorial jurisdiction. I am completely not on the cause of action. Cause of action, my lord, will kindly recall that Naveen Chandra Majatia judgment and subsequent judgment. There, if a fraction of a cause of action that might have occurred either in the Shillong or the Maharashtra, either of the court will have the jurisdiction. my lord.
Courts would have the jurisdiction. Yes.
Yeah. So therefore, my lord, that the great judgment, Marwari versus Magician, my lord, 1867, 1 crunch, page 137, my lord, propounded by the Lord Marshall, my lord, the Chief Justice of US High Court, Supreme Court, wherein it says that the purpose and objective and the power jurisdiction of the judicial review, my lord. So therefore, my lord, it is at the appropriate wisdom of my lord to take a call whether the bunches of the writ petition that has been transferred from Itanagar base to Guwahati, where there is a existence of a bench in Itanagar, per se both the division bench as well as the single bench, my lord.
Yes.
I am concluding with one more limb of submissions, my lord.
Yes.
My lord, with great respect, my lord, kindly do not take us on a board that this writ petition has been filed with questioning the authority and jurisdiction.
So we have said repeatedly said, Ms. Tara, don't even
Well,
think of
great.
it, that any view will be taken adverse to the lawyers or the associations because this writ petition has been filed, questioning the jurisdiction. You know, I'll just let you know that I have had the good fortune of appearing before chief justices, before whom
Great.
we stood and criticized their own judgments, and they were great enough to say that yes, even we have a right to correct our mistakes. So rest assured, there is nothing wrong in your making the submission. We appreciate
Great.
whatever arguments are coming from learned counsel. There is no difficulty about that. Yes.
No, my lord, that transferred order issued by the Honorable Chief Justice is administrative in nature.
Yes.
Administrative in nature, and it is an administrative. Now, a larger question comes up whether administrative order can override the statute.
Yes.
So therefore, my lord, will kindly have a rational look into it, my lord,
Yes.
without undermining uh, the power of the Honorable Chief Justice in transferring the matter from Itanagar bench to Guwahati High Court. my lord.
Yes.
We are at the bar, my lord. We are in agreement with the Lordship's question. If this writ petition is argued on the basis of the cause of action and the territorial jurisdiction, it will have a far-reaching ramification for us as well in Itanagar branch. The opinion that has fallen from my lord, to my understanding, is a correct proposition of the law, because it will entitle us from filing a writ appeal in Guwahati High Court if this writ petition is decided on this particular portion of law. Therefore, my lord,
Mr.
kindly
Tara,
apply.
what you have said right now, that is the crux
Right.
of the matter. The Chief
Correct,
Justice
Lord.
doesn't decide in his discretion that a matter of which the jurisdiction is with the Itanagar bench should be filed in Guwahati. That is the rarest situation. The filing may be done there in Itanagar and then the matters are transferred. But filings, yes, they are allowed in rarest situation, wherein perhaps there have been instances wherein lawyers have expressed threat to their life. In that event, we may allow. Otherwise, it is a routine dismissal of such prayers which come up before the Chief Justice every other day. Allow us to file the petition in the Guwahati High Court. It is
Correct.
rejected in routine
Correct.
because now
My lord,
there are refilings. Now there are refilings. Where is the question of having any issue of jurisdiction? File the matter by the filing mode. It will be taken up. So in
My
all
lord,
for all what we know that these petitions were filed in Itanagar and then they were transferred. Is that right?
correct.
So there is no question of cause of
Therefore,
action
my
being
lord,
usurped. There is no question of cause of action being usurped. The cause of action will always be retained by the Itanagar bench whenever it arises within the jurisdiction of Arunachal Pradesh. Only
my lord,
for administrative exigencies and convenience, the particular matters which Mr. Patin just now pointed out, that 86 in 10 years have been transferred to Guwahati. Okay,
so, my lord, may I make a proposal?
yes, please.
My lord may keep this writ petition pending, and can it be sorted out by administrative means, my lord? Why I am saying so? Why I am proposing, my lord?
Yes.
If any law is laid down, my lord, it will have a far-reaching implication for both the benches, my lord. Because the elders sitting in
Law is already laid down in Rajasthan High Court Advocate Association matter, wherein we read
Well,
para 18. That is the law. That yes, cause of
I am
action,
good.
Chief Justice is no one to decide, because that is
Correct.
decided by the presidential order. The
Because
only
my lord,
discretion is exercised. For discretion, there is no law required.
no,
There's
because
a presumption
there are
that the discretion would be
there is-
exercised judiciously.
correct. Well, there is two things, my lord. My
Yeah.
lord is the first among the equals, among the brothers and sisters judges, my lord.
Yes.
And he presides, he is the master of the master of the roster that refers to Chief Justice of any High Court to constitute the benches, to hear the matters, and, my lord, to allocate the functions between the brother and sister judges of my lord. So therefore, my lord, we are not quarreling on that, my lord. Let us have a mediation in this matter, my lord. How best we can have resolve this issue, my lord, administratively. In any case, my lord,
We'll consider
any
your submission. We'll
Yes.
consider your
So-
submission. All right.
yeah,
Thank
therefore, my lord, by a stroke of pen, my lord, we are going to decide a very important issue by application of the mind. At the same time, my lord, we are all human, we may err with certain exceptions, my lord.
Hmm.
I'm grateful, my lord, for the privilege.
Thank you. Thank you, Mr. Tara. Yes.
My lord, just taking a clue from Mr. Tara, if these issues are not to be decided, the best course would be, now the discussion, my lord, everything is very clear. The cause of action has not been resolved. In Rajasthan, the cause of action was resolved.
Precisely,
Then,
precisely.
my lord, the Supreme Court said, you cannot.
Yes.
Now, my lord, here one fundamental factor. It is not disputed that these matters arose or arisen in Arunachal,
Yes.
within the
No
territorial
dispute,
jurisdiction
no
of
dispute.
Arunachal.
Lower
No dispute.
Subansari.
If it has arisen within the territorial jurisdiction of Arunachal, as a master of roster, and my lord,
Not even master of roster, Mr.
by this,
This is not a matter of master of roster.
no,
This is a matter, some reason, underlying reason for which the discretion has been exercised.
my lord, that reason is for my lord to consider and
Precisely.
my lord to take a call.
Precisely.
It's there in the proviso.
It is for the
No,
Chief Justice to decide.
They decide. And my lord, when this is done in the administrative side, no hearing is required to be given to anyone, my lord.
Exactly, exactly.
But if a party makes a request before my lord,
Yes.
that I want this matter to be transferred, then the necessarily my lord will have to give a
Then
hearing to the
Mr.
other
Nair
side.
will let you know the applications are rejected right, left and center, saying that you have to approach on the judicial side.
The notification that is there before my lord,
Yes.
it pertains to, my lord, not the proviso under in page 349. It provides, my lord, if there is no appropriate bench in, my lord, it uses the word then.
Yes, yes.
Appropriate bench.
Yes.
If an appropriate bench is not there, will the litigant of that area
Yes.
or that bench be led to, my lord, no, without any remedy?
Remediless. Yes.
So it is under that circumstances that notification, it has got nothing to do with
Nothing
the
else,
proviso
nothing
here,
else.
my lord.
Yes, yes.
One. And now, my lord, Mr. Patil relies on a judgment of this honorable court. My lord has read the whole issue. My lord will have para 39, my lord.
39. Yes.
Justice Ansari's judgment, my lord. It relies on, my lord,
Rajasthan High
Rajasthan
Court.
case. And then what happened here, my lord?
Mm.
What surfaces from the above discussion as regards scope of a proviso is that the proviso appended, my lord, I'm sorry,
Just a moment. Yes.
para 39, my lord.
Yes, please.
What surfaces from the above discussion as regards the scope of a proviso is that the proviso appended to para 2 of the notification aforementioned merely carves out an exception to the main provision to which it has been enacted. When the language of the main enactment, that is para 2, is explicit and unambiguous, the proviso can have no repercussion on the interpretation of the main enactment. The proviso has to operate in the same field in which the main enactment, that is paragraph 2, operates. A careful reading of the proviso to paragraph reveals that the Chief Justice may, in his discretion, order that any case or classes of case arising in the state of Meghalaya be heard at Guwahati. This in turn implies that the Chief Justice can direct a case or classes of case to be heard in Guwahati, provided that the case has legally and constitutionally arisen within the state of Meghalaya. If in a given case no cause of action has arisen within the state of Meghalaya, paragraph 2 of the notification will not be attracted, and consequently, the question of applying the proviso to para 2 or taking recourse to paragraph 2 will not arise at all. To put it differently, if a case has not arisen in accordance with law within the state of Meghalaya, the permanent bench at Shillong will have no jurisdiction, and by taking recourse to the proviso to paragraph 2 of the notification aforesaid, the Chief Justice cannot direct that matter to be heard at Guwahati. The power given to the Chief Justice under the said proviso will come into play only when a case has legally arisen within the state of Meghalaya. The question as to whether the case has legally arisen within the state of Meghalaya is a question which is to be answered judicially and cannot be decided administratively by the Chief Justice. Hence, it is the judge or judges hearing the matter who will have the power to determine as to whether a case has arisen within the Meghalaya or not, in order to attract the jurisdiction of a bench of a common high court. Now, my lord, here the case was, there was no cause of action at Meghalaya,
Precisely.
but still the
Precisely.
matter was transferred.
Yes.
So conversely, if we read it, my lord has the power if the matter arises in
In Arunachal.
Arunachal, and
That
that is
they-
why, my lord, provided that the Chief Justice of the High Court may in his discretion order that any case or class of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati. My lord, it's only rarely issued, and that power, my lord, should not be curtailed, not for today, my lord, even for future. If, my lord, that power is curtailed, there may be a situation which may not be judicially, my lord, perfect. And my lord, there is nothing. They had an apprehension. I think the confusion was made between cause of action and the proviso. My lord.
Proviso.
I think that has now been cleared. My lord. So if they withdraw it, it gets a quietus, or my lord will have to.
That is for Mr. Patin to decide and Mr. Tara to decide.
And there is also a, my lord, IA, I think, filed by the NHPC. They are also supporting that the matter should be heard here.
Yes,
My lord,
you heard the
Uh,
arguments by Mr. Nair, Mr. Patin. So.
yes, my lord. Now, my lord, in this paragraph 39,
Hmm.
may I just draw your lordship's attention that there is one line, a few lines. My lord, the question as to whether the case has legally arisen within the state of Meghalaya is a question which has to be answered judicially and cannot be decided administratively by the Chief
Yes,
Justice.
yes.
Now, my lord, my respectful submission would be that whatever the decisions has been taken, were taken on the administrative side, not
Yes.
judicial.
Mr.
from
Patin,
judicial
the decision doesn't pertain to the issue of jurisdiction. The decision is only where the matter will be heard. That is the only decision. Where was the filing done? Just
No,
answer
my
that.
lord.
Where was the filing done?
Now, my lord, another issue is
Where was the
But,
matter filed, Mr. Nair?
It was
Since,
filed in
uh,
Arunachal.
So
My lord, it's not
just now, in order to answer your anxiety, the filing was done at Arunachal Pradesh. The registry did not refuse to register on the ground that there is no jurisdiction with the bench. That is right.
no.
So the
Yes.
issue of jurisdiction is decided. It was entertained at Itanagar, and then the proviso came into picture, and the matter has been transferred. It is as simple as that. That aspect, even time after the matter has been heard, Mr. Patin's signal seemed to have been a little bit
My lord,
compromised.
He's come.
no, my lord.
He's come back. He's there.
But we will abide by whatever the decisions that your lordships will
Yeah,
render.
that's
My lord,
fine.
our submission is that, my
Yes.
lord, at times the litigants' confidence has to be also taken into
Mr.
account.
Patin, we are telling
My
you,
lord, here,
we are trying to
here, this,
you see, this is just something not concerning this petition. We are trying hard, our level best, to ensure that the best VC facilities are available in Arunachal. You probably recollect that when Mr. Tara called us, the association, we had that discussion that we will ensure that lawyers from Arunachal can even appear and argue matters pertaining to the Guwahati jurisdiction. Why shouldn't that happen? Why shouldn't
Yes,
you be engaged and argue matters before the principal seat, even those which are not arising in Itanagar? You are very competent people, all of you.
Making base use of the technology. I appears in Apex Code through virtual only, Milan.
So that's happening every day.
we are
hear
grateful
lawyers-
that your lordship has taken personal initiative also with that. But my lord, when Mr. Nair was making some submissions that NHPC has filed an IA
we don't
supporting
take
the
cognizance.
transfer.
We don't
My lord,
take
in fact,
cognizance of that application.
My
We
lord,
don't
in
take
fact,
cognizance of that application, Mr. Patin. We are hearing
my
your
lord,
petition as such.
yes, my lord. No, my lord, I'm
Well-
just giving an information to your lordships.
Yes.
My lord, the first case which was filed by the NSPC at Guwahati High Court, at the principal seat Guwahati, my lord, in that application, only the NSPC had requested that the case filed in the Guwahati principal seat Guwahati should be transferred to Itanagar.
So that's why we are saying that we have not accepted anything on the judicial side. Whatever transfer has been made, it has been made on the administrative side and not at the instance of any of the parties.
My lord, if I may be allowed to interject for a moment.
Sure, please carry on.
Lord, just I'm making a respectful prayer.
Yes.
Kindly keep this matter pending.
Mr. Tara,
we will-
there's no need, because the issue of jurisdiction is not at
No,
all.
no, I'm not on
Reason
to that.
before
my
us.
lord.
And that
There is no
power,
quarrel on this.
the discretionary power, we don't want any loose ends to be left, Mr. Tara.
Lord, can we resolve?
Create
No,
havoc
that's
for
why, my
you.
lord, can we-
It will create havoc in all the three benches. We are telling you.
Correct.
The
That's why, my
situation
lord.
may arise. So
That's why,
let
my
the
lord,
issue be decided.
I'm in,
Good that Mr.
I'm
Patel
inject-
has brought this issue up. We'll decide it and set the matter at rest. Thank you.
My lord, I've
Arguments are
given-
order resolved.
My lord, I've given the state.
There's an
Arunachal Pradesh-
application there, yes, in the supplementary.
There is an application, but that can be, it need not be, because otherwise
Yes.
also the issue is, my lord, is hearing the issue, no?
We'll consider the application after deciding the writ appeal, while deciding the writ appeal.
My lord,
Arguments are order resolved. Yes.
the state of Arunachal
Right.
Pradesh Act,
Yes.
under which it was made, I've just given copies, my lord. Para 18 to 26, my lord, Common High Court,
Yes.
my lord, 18,
Section 18.
section 18, my lord.
Yes.
Once Arunachal came in, my lord,
Hmm.
then, my lord, Common High Court of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. On and from the appointed day, there shall be a common high court for the states of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, Arunachal Pradesh, to be called the Guwahati High Court, the High Court of so and so,
Hmm.
hereinafter referred to so and so. The judges, but then, my lord, would come to 24,
Hmm.
the principal seat and other places of sitting of a common high court.
Hmm.
The principal seat of a common high court shall be at the same place at which the principal seat of the High Court of Assam, Nagaland, Meghalaya, Manipur, Tripura, and Mizoram is located immediately before the appointed day. Then, my lord, Arunachal comes in. The president may, by notified order, this is under that 349 page.
Yes,
my lord,
349.
provide for the establishment of permanent bench of benches of a common high court at one or more places within the territories to which the jurisdiction of the high court extends,
Yes.
other than the principal seat of the high court, for any other matter, for any matter connected therewith.
Hmm.
My lord, the jurisdiction exercised by the Arunachal bench is a
Jurisdiction of the Guwahati High Court. That's right.
And for administrative convenience, that was done.
Yes.
Cause of action, my lord, cannot change.
Yes. But this section 24 kind of provision was not considered in Hindustan paper. Hindustan paper
24-2, it went directly to the, my lord,
to the
the
presidential order.
order, my lord.
Yes, yes. This is a very important part. Yes, Ms. Patel, have a look at section 24-2. This changes the scenario now. Of the,
The president may by notified order provide for the establishment of a permanent bench or benches of the common high court at one or more places within the territories to which the jurisdiction of the high court
jurisdiction of
extends,
the High Court
other than the
extends.
principal seat of the high court. And
So
for that matter,
the territories for which the permanent benches have been have been formed, the High Court has the jurisdiction, and the High Court means the Guwahati High Court. So if you ask us to decide now on merits, probably or even on jurisdiction, the things may take a different color. Because the principal act of 86 says jurisdiction of the High Court, even over the areas where the benches are formed. So presently we are only exercising discretion, then it becomes a mandate of law. Any litigant would say, I want to file it in Guwahati, there is no one to stop them. We can give you a couple of days time to think over this. We can give you a couple of days time. Think over this.
Miller, I personally pray, kindly keep the matter pending.
Tara, we'll not keep it pending. No, we'll not. We don't accept that prayer. We'll not keep it
Miller,
pending.
we will come down and resolve the matter administratively, Miller.
There is no question
is
of
my
resolving, Mr. Tara. That's a power left to the Chief Justice. There's no question of resolving. All resolutions are there in the presidential order. So we'll post the matter on Monday. Mr. Patil can come back and let us know his thoughts on 24-2. Yes,
Yes.
on Monday. All right. We are not taking up. All right, we'll see. All right. That's not on the judicial side. We have direct transfer. Mr.
Lordship.
Yes. 28.
Item number 14.
May I please, your lordship?
Yes.
Well, the lordship is very much aware, my lord, regarding the parking problems nowadays, my lord. My lord,
Issue notice to the respondents. Steps of service be taken in 3 days. Standing counsel so and so appear for the respondents numbers
1, 2, and 3.
1, 2, and 3. Steps of service on the respondents numbers 4, 5, and 6 be taken within 3 days without process be issued.
my lord, I have an step here because the construction is work is going on, my lord.
No, stay, sir.
That
No
may be-
question. Infrastructure projects,
My lord,
specific relief act section 20A.
my lord, I have no objection in that, my lord, this should not be constructed. My lord, it should be constructed in a municipal law contained by the my lord,
Let
municipal
the other
law.
side come, sir.
My lord, this is the my lord, public bus stand where the municipality has no right, my lord, this is a government land. They don't have their land. And in the public, my lord, road, my lord, they have
All right,
constructed it, my
sir.
lord. Over the, my lord, PWD road, they have constructed, my lord.
Prayer for interim relief declined.
Item number 15.
May I please, your lordship, my lord, in this matter, I pray for a short date, my lord. My
On
lord,
16th, we
15.
16th, we directed you to take instructions regarding the affidavit.
Yes, my lord.
Of the
To
appellant.
file a reply, my lord. We have sought for instruction. It may be fixed on the coming Wednesday, my lord. By that
Ms.
time.
Bora, please for further opportunity for responding to the government as responding to the observations made in the order dated 16/8/23. They notify. We'll give it in the September, second week of September.
This is a medical student matter. So, the agency.
He was sleeping for 11 years.
No,
Doesn't matter.
sleeping. Your lordship is, your lordship wanted to see whether he really suffered or not. So
Or
according to
29th.
the education, or otherwise, subject to what your lordship may say.
29th,
National Medical
Obliged.
Commission, your lordship may
Let it
directly
come on
decide the
29th.
matter.
29th
Obliged, my lord.
August.
Item number 16.
My lord, in this case, the writ petitioners are saying this, the provisions of the Assam Cattle Provision Act 2021,
Assam.
Assam Cattle Provision,
Hmm.
Cattle Protection Act
Hmm.
2021, on three grounds, my lord. First ground is, my lord,
We'll admit your petition and then hear it finally. Can't be decided at motion stage.
is fixed for admission today. It is
Mr. Saikia, we'll admit the petition.
Yes, lordship.
only my prayer, my lord. Some insist that your lordship awarded early hearing. I'll be grateful.
We'll hear it. He'll hear it on the turn, sir. Admit issue notice. The respondents are represented by Advocate General Assam, Mr. Saikia, and
Kutoki,
on behalf of
Animal Husbandry and Veterinary Department.
respond number 2 for respond number 2, market presence. Do we need service to be effected on the respond number 7? It's a
My lord,
former respondent as per you.
Already taken.
All
Already
state
taken, they
respondents.
filed the affidavit also.
Oh, no, 7 is Meghalaya.
7 is Meghalaya.
Meghalaya.
Do you want
Justice service has been.
permitted? If it has been effected or what?
Effected and additional affidavit has been filed.
Has been filed. All right. The respondents are duly represented, thus notice need not be issued. List for hearing.
Well, if lordship give us, my lord, first week of next month.
Not possible, sir, right now. To file an application for early hearing, we'll consider that.
Well-
Right now, it comes on its turn.
Highly
Yes.
I love it.
Item number 17.
17, my lord, we had filed an affidavit yesterday.
We filed the affidavit.
And also, my lord, I'll make you kind notice, my lord. In this case, my lord, this eviction, we are facing a contempt, my lord, suo motu contempt. Let it be listed together, my lord.
Affidavit on behalf of the Forest Department has been filed as per, as stated by Mr. Gogoi. The same be brought on record. It's
And tagged with, my lord, suo motu contempt, my lord.
the file of suo motu contempt number so and so shall be tagged with this writ petition, and both the matters shall be listed together on 21st September.
Public.
May I, your lordship, an affidavit was also filed on behalf of respondent number 1 and 5.
That is already on record.
1 and 5, your lordship.
On 9th
what has
August.
happened- Yes, your lordship, there's a typographical error, minor typographical. Also, your lordship, annexation number 2, somehow it couldn't be annexed with the.
You have to supplement that, file an additional
Yes.
affidavit.
No,
Passover method 10.
We wanted the status report.
Yes. Mr. Barua,
My lord.
status report.
Yes, my lord.
Mr. Lordship, with your permission, because those letter is written to me, I am placing before Lordship, instruction, status report.
You file it in the office, Mr. Bora.
My lord,
File it in the office with an affidavit.
by affidavit.
Yes.
Yes,
Mr.
that I'll-
Barua.
Yes.
Submit that he has received the factual report and would be filing the same on record with an affidavit within next 2 weeks.
My lord, I'll oblige.
List in 3rd week of September.
Much obliged.
Oblige.
दे दीजिए.
Supplementary item 40.
May it please your lordship. Look, this is a matter wherein the petitioner has been sought to be transferred from my lord, Longding to Itanagar, which is about a distance of 400 kilometers. Only 10 months service left in his service career, my lord. This is going on, my lord, 8 months, 10 months, 5 months.
The earlier case was 4 months, my lord. This 10 months, my lord, there may be 1 month here and there, my lord, but the executive policy is there to transfer a person 1 year before the retirement. That policy is there.
Yes, so then why do it 10 months before, just 10 months left to go? Why?
Well, the other factors also have to be seen, my lord.
What are the other factors? Tell us.
Well, records may be called from, my lord, you're also candidate. I'll produce the
But
record.
then he has not been relieved as yet, we are told. And
My lord,
we'll
what happened? The
Well,
private
but
respondent.
I had already joined, well.
already relieved.
No, my lord, what happened? The private respondents, while I was on sick leave, my lord, on the day when the first round of litigation was there before the learned single judge, my lord, he unilaterally took over the charge, my lord, without any order from any higher official.
Now let Mr.
That is not
Issue notice,
permissible.
Mr. Goswami, Additional Advocate General, Mr. Goswami,
Well-
puts in appearance on behalf of the respondent number 1 and 2.
Yes, ma'am.
Process be issued to the respondent number 3. Heard on a prayer for interim relief. The appellant has been transferred at the time when he has only 10 months to go for his retirement. In view of the above, we hereby direct that there shall be a stay on the impugned order of transfer dated
19/24/7/2023, my lord.
It's 37.
rule is made returnable in 4 weeks.
Much obliged.
That matter from yesterday. Final disposal. The parted matter will have to be taken up first.
Supplementary list, part matter, item 36 to 38.
My lord, sorry, my lord, this final disposal matters. It will take some time, can run some other day, my lord.
You can take a date, whatever is suitable,
My lord.
in October.
So for item number 20 is concerned, my lord, your lordship kindly peruse the last order, my lord.
20.
Yes, my lord, that last order has said, my lord, that pleading on behalf of the petitioner still maybe next week. We make it clear that no further time shall be granted for filing pleading in this case. The intended operating so and so shall continue till next date. As paid for list this matter for final disposal on 24/8/2023. And my submitting before your lordship is there. I have a stay waiting application file on 21 May. That was not disposed of till today. The issue is very simple on law point. whether in tribal bench.
Maybe very simple for you, sir. It will find it very difficult to discern.
My lord, one thing is that, my lord, the order passed in Vidyut Bora, the order passed in the super light case, my lord. Contrary to the order passed by the division bench, my lord. And it was pending for last 3 years, man.
When was the stay passed?
Yes.
When was the stay order passed?
It was passed on, my lord, 2021, my lord.
So there have been two years have lapsed. Wait for a few more days.
Only thing next day, same thing is going to happen.
It will not happen because.
My lord, because my lord,
If we had the, Mr. Chaudhary, if we were sitting for the entire day,
Yes, yes,
we would have taken up these matters.
yes, my lord.
But we are having a different bench at 2 o'clock.
Yes, my lord. Yes, my lord.
That's the
I
reason.
appreciate. You also may it's a short date, my lord.
Yes,
Because
yes.
I have a stay vacating application, my lord, and that was not hard, my lord. And
Don't worry. As jointly prayed, re-notify on 5th October for final disposal.
My lord.
Interim order already passed shall remain in currency till next date.
my lord,
Deeply
on that, the
obliged.
disposal shall be made. my lord.
May I please, sir?
We can only hope.
This is one offshoot of the case, but the main case is regarding the encroachment in tribal blocks. and-
Tribal block says that is Pradyut Kumar Bora.
Yes,
Yes,
Lordship.
my lord.
In that case, Lordship, we were seeking one special observation from this honorable court. The state government wants to do a census of the actual number of persons who are occupying this kind. If that observation is given, Lordship, because Lordship is taking up the matter for final disposal. In the interim, the state government
Can
can.
you move an application for
I'll-
seeking that
I'll-
direction? Then we'll pass the order.
Lordship.
Move an application with your propositions. Bring them on record, then we'll pass the order.
Lordship.
Yes.
Deeply obliged.
My problem is that, my lord, one after another case has been filed pending before the single bench, my lord. And my lord.
Once we decide this, Mr. Chaudhary, all the controversy will be settled. Then, Mr. Saikia, should we fix it at a shorter date,
Yes.
mentioning that you want to move an application?
Yes, Lordship.
Take down. The Advocate General appears, Mr. Saikia appears in PIL number 78/2012 and PIL number 22/2019 and submits that the state is desirous of carrying out a census in the area under consideration of this court in this PIL, and that he would be filing a formal application seeking permission for such a course of action. The requisite application be filed within next 7 days.
Yes, Lord.
Re-notify on 12th September.
Lord.
Interim order in currency in the concerned writ petitions shall remain in force till next date of listing.
Deeply obliged.
Yes.
May it please your Lordship. Yesterday, I was placing one judgment of the Delhi Education Rules of 1973, where the Honorable Supreme Court upheld the role of the directors. That is in respect of the Delhi Act, Lordship, of 1973. I would like to place in a very
What is
short.
the ratio in PA Inamdar, Mr. Saikia? Can you read that? That judgment probably would hold the field. 2005 volume 6.
Yes, Lord.
SCC
That judgment
537.
I have, but today I have 4 other judgments that will not be possible for me to today place it.
Okay.
I am looking at that judgment also.
Okay, very well.
So today I would like to place 2-3 judgments as well as our act from the perspective of what exactly the role placed by the director. Because there one of the main plank is that the director is given excessive power, unbridled power, uncanalized power. So whether that is there in our act or not, if Lordship is pleased to take up the act itself, I will place only few sentences from the act. 572.
Act is there in the file itself. It is-
If Lordship is pleased to take up the book, because the preamble statement and objects were not part of the records in the memo of appeal.
572.
And Lordship is pleased to take the new one because a lot of amendments have taken place in 2018.
This is the latest one.
Yes, Lordship, I think that is the latest one. 572.
Yes.
I would like to place 3-4 parts of this. First is that, Lordship, the preamble, 573, the Whereas it is expedient to regulate the establishment and management of non-government educational institution in the state of Assam and for matters connected thereto or incidental thereto. Statement of objection reasons. The unplanned and mushroom growth of non-government educational institutions at primary, secondary, and higher secondary level in the urban and semi-urban areas of the state have necessitated to make law to regulate the establishment and management of all non-government educational institutions, that is, educational institutions established and run by individual associations of individual society trust at primary, secondary, and HS level without receiving any grant or financial assistance from the government. It is observed that there is an increasing trend for commercialization of education, and many educational institutions have established with the sole motive of earning profit with scant regard to the standard norms of land, building, classroom, furniture, library, laboratories, fire safety, playground, etc. The teaching and non-teaching staffs are paid meager salary and their services are terminated or dismissed on falsy grounds without giving reasonable opportunity to defend themselves. The state government at times have to remain a silent spectator in spite of a large-scale resentments expressed by the public. As such, it is expedient to provide for law to regulate the establishment and management of all the non-government educational institutions functioning in the state and those to be established in future. So this is the object and reasons of the act. Now, this is one part because my judgment will be directly relating to this aspect also, as well as the role of the director. Now, what is the role of the director? First, we have to take wherever the name of director is figured, Lordship, I place only those portion of the act. Definition of director, there are two levels of directors, one at the secondary level, one at the elementary level. So 2 Roman 2. And there are certain other officers also, which are including the executive engineer of PWD division, because he has, in some areas, Lordship, he has to depute a particular officer. He cannot go into all the areas. So where there is a requirement of the executive engineer PW, then also he can take his service if it is case of a building. Now coming to the definition of non-government prescribed. Prescribed is very important, Lordship. Roman XVII, that is 17. Prescribed means prescribed by rules made under this act, the definition.
Yes.
Now coming to the role of director, in what areas he has some role. Section 4. In section 4, one important aspect which the other side was arguing that I would like to place right now, it's about 5th line. My learned senior friend, Mr. Borbora, argued that the word may is there. Now this was amended in 2018 and shall has been inserted there. So it is made mandatory, not directory anymore. If Lordship is pleased to read, any individual association, individual non-government organization, society or trust intending to establish and run a non-government education and on given an undertaking to fulfill the requirement as laid down under section shall. It was earlier may. So this is one part. Next part is number 2. On receipt of the application, the director, after considering the particulars and information contained in the application under subsection 1, and after such enquiry he may deem necessary, may either grant or refuse or grant prior permissions to the applicant for opening a non-government educational institution. Here, the application has to be given to the director and he will look into it. Provided that the director may refuse to grant permission if he is of the opinion that the particulars and information furnished in the application do not fulfill the requirement as laid down in the act and rules thereunder for reasons to be recorded in writing. This has some relevance later on, Lordship, but I have just indicated. On refusal of grant permission under subsection 2, the director shall communicate the same to the applicant, stating reasons thereof. In the event of refusal to grant permission under subsection 2, the aggrieved individual association of individuals, non-government organizations, society trust may prefer an appeal before the state government whose decision shall be final. So even without 28A, Lordship, there was already a provision of appeal before the state government. Now, 5, the permission granted under subsection 2 shall remain valid for a period of 2 years within which the applicant shall establish the institution and register the same before the director. 6, if any reason for which the director considers to be genuine after an application being made in this behalf by the applicant, who has failed to establish the institution within the stipulated period of 2 years, the director may grant extension of the time for further period which shall not exceed 1 year in all. So this is the role of the director as far as permission is concerned.
Yes.
Next is administrative recognition. After establishment and registration of the non-government educational institutions under the subsection 5 of section 5 of section 4, the authority shall make an application on payment of such fees and in the form and manner as may be prescribed before the director for obtaining administrative recognition in respect of the institution. So that application has also to be furnished, given to the director. 2, on receipt of the application for administrative recognition, the director shall make or cause to make such inquiry as may be considered necessary to ascertain as to whether the requirements as laid down in under the act and the rules made thereunder have been fulfilled or not, and whether the school authority has acted in accordance with the stipulations made in undertaking referred to in section 4 or not. Submit a report to the administrative recognition committee constituted under section 7. So when this administrative recognition is sought and applied, lordship, he will do a verification and submit a report to the administrative recognition committee, which is considered under section 7. If lordship is pleased to look at section 7 for a moment.
Yes.
Constitution of the administrative recognition committee. 2 levels are there. If it is in the level of imparting education at secondary and higher, it is the director secondary education. And along with him, there are several other persons in the committee. Joint director of secondary, 1 state government representative not below the rank of deputy secretary, secondary education, 1 representative each from the SEBA, 1 from the higher secondary education council. And identically, lordship, in respect of the primary and middle school, the director elementary is the chairman, and there are other officers, including 1 representative from the State Council for Education Research and Training, that is SCRT, not below the rank of joint director, along with 1 deputy secretary level officer. Again, coming back to the administrative recognition. After 2, I am reading now 5.3. The administrative recognition committee, after considering the report submitted by the director and after examining such other information as may be considered necessary, may make recommendation in respect of non-government educational institution for its administrative recognition by the director. So the director is not the person who will take the final decision. The decision is to be taken by the administrative recognition committee. If the administrative recognition committee is of the view that the school authority of an institution has failed to fulfill the requirement as laid down in the act or the rules framed thereunder, or any stipulations in the undertaking as referred in section 4, no recognition shall be made to the institution for reasons to be recorded in writing. So if the committee also refuses, then they have to give reason. And if it is granted, then what the director will have to
Time limit prescribed under which these actions have to be completed.
in the rules.
Is there any time limit? Supposing the application is filed in May,
Yes,
how long will it take for the process to be completed?
yes, Lord. I'm coming, Lord. Just,
Can the institutions be left hanging at the discretion of the director?
yes, Lord.
Is there any time limit?
I'll just.
Find out in the rules. There must be something in the rules.
Yes, Lord.
Yes.
There is a supplement rules, Lordship, where specific time limit is given, 15 days. I'm placing it, Lordship. It is just coming.
It's not there in the book.
This book has, there is a supplement to this book, my lord, newly come up day before yesterday or some 2 days back. That contains the amended rules, my lord.
Supplement to the book.
No.
So this is a later book, Mr. Mazumdar.
This is
After
this book.
In 20.
Get it from the library. Get it from the library. Yes.
So Director 5.5, the director shall issue order granting administrative recognition or refusing to grant such recognition to an applicant in accordance with the recommendation of the administrative recognition committee. Any applicant whom the administrative recognition is refused may prefer an appeal before the government, state government, whose decision shall be final. So the appeal provision was also in respect of administrative recognition also. Now coming to the existing ones. 6, registration and administrative recognition of existing non-government educational institutions. What is the director's role here? The existing non-government educational institutions shall submit applications for registration of their institution before the director, furnishing the full particulars and information and on payment of such fees as may be prescribed relating to the institution sought to be registered, and shall also furnish the copies of the government permission or recognition, if any, previously obtained before the academic recognition from the respective board or council, as the case may be, within a period of 6 months from the date of commencement of the act. Provided that in case of failure of any institution to register the institution under subsection 1 of section 1, within the stipulated period, the institution shall be allowed to registration on payment of the fees with 50% increase of prescribed rate, provided the institution is registered within a period of 1 year from the date of coming into force of the amended act. So this is another handle. These are all amended provisions of 2018, which was not placed by the other side.
Yes.
In the event of failure of any institution to register within 1 year as stipulated above, the director shall issue notice to close down the institution in a phased manner, not abruptly. That there shall not be any admission in the lowest class of the school from the next academic year, and such institution shall completely close down after passing out the highest class of the institution. So it is not that abruptly it will be closed, new admission will be stopped, and the highest class they passed out. So it will get a leeway of another 3-4 years.
Yes.
This is precisely what we did when we closed down the provincialized madrasas, Lordship. There also we give that opportunity. So this amendment came in 2018, Lordship. It was not in the original act.
Yes.
Now coming to the next. On examination and consideration of the application and information furnished by the existing institution under subsection 1, the director shall provisionally register the existing institution pending such enquiry and inspection as may be prescribed for final registration of the institution. In the rules, Lordship, in what areas the enquiry and inspection can be done, I have placed, if required, I can indicate that once more. Next, immediately after provisional registration of the existing institution, the director shall make or cause to make an enquiry or inspection of the respective institution, and the existing institution have been found, established, and run with the permission or recognition from the state government or director possessing the requirements as laid down in section 10. So whatever is prescribed in the act, we will have to look into that aspect only. And the rules made thereunder shall be granted final registration. The existing institutions which have been established and run with or without the permission or recognition of the state government or director, without having the minimum requirement as laid down in section 10 or the rules made thereunder, shall have to fulfill the requirement within a period of 2 years from the date of commencement of this act, after which the institution shall be finally registered. The existing institution which have been established or run without the permission or recognition of the state government or director and fulfilling the requirements as laid down under section 10, and the rules made thereunder shall apply for obtaining administrative recognition from the director within the period of 6 months from the date of commencement of this act. After giving administrative recognition, those institutions shall be finally registered by the director. The provisional registration and recognition, etc., of the institution which have failed to fulfill the requirement as laid down in the act and the rules within the time frame stipulated in this section shall be liable to be cancelled, and the institution shall be liable to be closed down under the provisions of this act. That means that phase manner.
Yes.
Then Lordship kindly come to section 9. Here also the director has no role regarding the other recognitions by the board and councils governing their own regulations.
Yes.
Then requirements of the 10, these are the parameters. Constitution of management committee, no role of the director. Scheme of management, there it has to be submitted to him.
Yes.
Section 14. The managing committee shall frame a scheme of management for the institution containing the salary structure and other conditions of service of the employees and the fee structures at all level of the education amongst other things, as may be prescribed, and which shall not be inconsistent with the provisions of this act and the rules made thereunder, and shall submit the same to the director for consideration, acceptance, and record. So he will have to be given the scheme of management. Now, what the director will do, 3, the director may approve or disapprove the proposed increase in fees if he is of the opinion that such a increase is necessary due to increase in the facilities provided in the institution, and may disapprove the for reasons to be recorded in writing. This area in 2018 was holding the field. In 2017-18, Lordship, the act has also come. And that act has to supplement that act. Yes. Oh, it is.
What is the name of the act?
Yes, I'm giving. Yep. Give me a second. এখন আমি ফিজ স্ট্রাকচার বুক না এটা কোন মু হেরি কোন দিতে প্রিন্টেড কোন আছে প্রিন্টেড কোন হলো It is in the book and I have 3 printed copies also.
What is the name of title of the act?
Huh? Page 146 is the structure of fees act.
In this book?
Yes. In this book, Lordship.
156.
Mark for us.
Non-government education.
It is called
Regulation of Fees Act 2008.
the Assam Non-Government Educational Institutions Regulation of Fees Act 2018. And on May 18th, it received the assent of the governor. Here, definition 2F, fees and fee structure. And it includes what? It is everything is included here. Like it includes the tuition fees, term fee, library fee, library fee and deposit, laboratory fee, gymkhana fee.
This is being enforced. This is being enforced.
It is being enforced. Present Lordship, there are 2 committees here.
Fee regulatory committee and
one is revision committee, one is regulatory committee. The fee regulatory committee, it is district wise Lordship, and the fee revision committee is under an honorable retired judge of the High Court. Earlier it was my Lord Justice Anima Hazarika. Now I think it is my Lord Justice Rumi Kumari Pukan.
Okay.
Then institution means and includes non-government education institution, etc. Local authorities are there. Management means what are the management? And definition of non-government educational institution P, 2P. Non-government means schools established and run by the individual. Same definition, last few lines. Without receiving grants from the state government which have registered under subsection 1 of section 1 of the Assam Non-Government Educational Institution Regulation and Management Act 2006. So it has a direct relation with that. Definition of profiteering is at S. Profiteering means any amount accepted in cash or kind, directly or indirectly, which is in excess of the fixed and approved as per the provision of this act, and shall include profit earned from school by trust or company associated with school in any manner whatsoever.
Mr. Saikya, just hold on. This has been substituted in 2020. This what definition you are reading in 2P. It has been substituted in 2020. You are having a printout fresh. In the book, it is at the bottom. Note. Wherein the reference is made to the Act of 2007. There's an amendment in 2P.
Yes, Lordship, it is amended. And for that, I have to take your Lordship to here. One provision is there. Section 18 of the same act. So we have to read conjointly, Lordship, here. Save has otherwise provided.
We are not saying that it is not so. We are saying that P, which is there in the book, it has been amended and the amendment is printed below.
Yes, printed, but I was reading from the printout, Lordship.
You are reading from the act, that is the difficulty. That is there. That's why we didn't find that under the act, registered under the Act of 2007, that was not there in the original provision.
Yes, I'm reading the unamended one.
Okay. You are reading the amended one from the printout directly.
No, the printout is the unamended printout.
2P in the book 150, page,
Yes,
take
yes.
out page 150. That is the unamended
Yes, yes.
provision.
It ends up with the Article 30's
Yes,
institutions.
in that
Yes.
the reference is not there to
That act
Act
is
of
not there.
2007. That is at the
Yes.
bottom. That is at the bottom.
That few lines were removed in the amendment part. What I am trying to emphasize is that, Lordship, that this act also, section 18,
Refers to other provisions
other provision, it will run in addition.
in addition.
Say when otherwise provided in this act, the provision of this act shall be in addition to and not in derogation of any other law for the
Yes.
time being in force. So there is no conflict. So we have to read both the acts together.
Yes.
So when the director will look into the fees aspect, he will have to refer to
Refer
this
to
act.
the Act of 2018.
Exactly.
All right. Yes.
And here, the role of the committee is very briefly I can indicate. Chapter 2, the government shall consider fees regulatory committee. It will be consisted of various persons, which includes Lordship. The committee section subsection 4 says the committee shall consist of the following members: retired district judge and district and session judge, or a person who has been a member of All India Services, having retired from a post not below the rank of commissioner and secretary, or a person who has been a member of IPS, having retired from the post not below the rank of Additional Director General of Police, to be nominated by the government, who shall be the chairperson of the committee. Then one chartered accountant, one civil engineer, government approved valuer, secretary, higher education council, one representative of non-government educational institution management to be nominated by government, one academician of repute to be nominated by the government. The director's role is very limited. Lordship will kindly see 5.
Coordinator.
The director shall act as a coordinator to the committee to provide administrative support.
Right.
So he does not have any opinion
Any role to
regarding,
play in fees structure.
he will just a facilitator.
Facilitator. Yes.
Then this the jurisdiction will be districts or zones as the state government notified. Section 4. Now coming to the procedure part is section 6, fees regulatory committee. And powers and functions at section 8.
Right.
Here also various procedures are laid down and functions also. And section 9, the fees regulatory committee shall recommend maximum limits of fees to be charged by different categories of non-government educational institution every year before starting the academic session, taking into account factors as mentioned under section 10. And the state government shall notify the same in the official gazette from time to time. The
Yes.
fees section 10, there's a power of the exemption part also. Then factors for determination of fees, section 11. The fees regulatory committee shall determine the fees leviable by different categories of non-government educational institutions categorized by the committee after taking into account the following factors: location of the school, then investment incurred to set up the school, infrastructure available, expenditure on administration, maintenance of service and utilities, strength of students, classes of study and courses of study offered by the school, qualification of teachers, non-teaching staff, and their salary component, reasonable amount of yearly salary increment, expenditure incurred on the students against total income of the school,
Yes.
reasonable revenue surplus for the purpose of development, education, and expansion of the institution, any other factor which may be prescribed by the government from time to time. The regulatory committee shall, after determining the fees leviable by the non-government educational institution, communicate his decision to the institution concerned. The fees regulatory committee shall determine the total fees which shall be levied by considering all different fees charged by the institution. The fees so determined by the fees regulatory committee shall be binding on the non-government educational institution for a period of 3 years. This also taken from the Supreme Court judgment. 3 years it is fixed.
Yes.
Then prohibition of excess fees are there. Then division committee, Lordship.
That is created by a
30.
retired high court judge.
Retired high court judge. The government shall constitute a committee for the purpose of revision against the order passed by the fees regulatory committee. The headquarters of the fees regulatory committee shall be at Guwahati or at such place as may be decided by the chairperson of the committee. The fees revision committee shall consist of the following person: a retired judge of the High Court to be nominated by the government shall be the chairperson of the committee. The senior most secretary to the government of Assam, secondary education, the commissioner and secretary, finance department, secondary director of secondary education, ex officio, who shall be the member secretary. One representative from the non-government educational institution of management to be nominated by the government. One chartered accountant to be nominated by government. A person or institution aggrieved by the order of the fees regulatory committee
Under section
may,
11.
under section 11, may file revision application before the fees revision committee within a period of 21 days. And there's a scope for giving delay condonation provision is also there. Now, regulation of accounts and maintenance, how the accounts to be kept, lordship, it is the regulation provides. Then contravention and penalties. Here that word offense is not used. It is in the better drafted one.
That is what we said the other day, Mr. Saikia, that your act as it exists is not properly worded. That's what the expression was.
But I have found various other states also use the word.
We'll, all right, now you may carry on, but we'll tell you where
those things
where
also
the
we are
act
always
is-
open for that.
just hold on, please. Where there are two provisions, one provision has been taken care of by the establishment of the tribunal and the provision of appeal, which was not there in the original act. The one provision which just doesn't stand to scrutiny, we'll let you know right now. Come to section 20 of Act of 2006.
Inspection or supervision.
Yes, seizure. Seizure, how it can be allowed is just absolutely draconian. You just contemplate a situation, Mr. Saikia. One fine evening, a director has a bone to grind against a particular institution. He decides, I'll inspect, I'll just malign the school. He calls the police by virtue of section 26. What is the role of police in an educational institution?
Here,
This will not stand to scrutiny, we are telling you. It will not stand to prima facie opinion, subject to correction, of course. Police
I will
and
agree.
seizure, two parts are absolutely unacceptable. Others, what you have argued based on Supreme Court judgment, fee structure is there. Otherwise, they can't have any objection because yes, this structuring and regulation is absolutely essential. There cannot be any two views on that. That is in consonance with TMFI. But these two provisions.
I'll address on those points of the whether the seizure power should be there or not.
Yes. Seizure power, even the police cannot enter a premise unless there is an apprehension of offense being committed.
Here, lordship, that,
Section 100.
I do agree, lordship. That
Yes.
is one aspect.
So
Here, why this sudden inspection is required?
sudden inspection, all right. But police.
Police,
see,
it
what
is-
will
it
be
is not
the
the police
situation?
normally.
No,
Suppose a particular person is running a school.
You have a power of closure. You have a power of cancellation of recognition. Why police is to be involved in an educational institution? Unless there is an offense, you can't take police.
Police is, lordship will kindly come to section 6.
Yes.
Assistant of police and civil administration.
Hmm.
Director
Section
may,
6.
as and when situation so demands.
Yes. So who decides that, Mr. Saikia, in this state of affair, there will be no right of appeal? No, the director one fine morning decides surprise inspection, take the police team with myself. Enters the institution,
Lordship
the
will have
entire
to-
reputation of the
lordship will
institution
have to look
is
into the
destroyed.
Ground realities of the
Yes.
state. Suppose a very criminally infested area in Assam. Lordship, we cannot see Assam from the perspective of Guwahati.
Saikia, come what may, we are talking of educational institutions.
Exactly, Lordship, in
Yes.
educational
See, all that,
institutions.
you satisfy the court plain and simple.
I'll satisfy.
We have given our
But-
expression
but
of opinion.
Directly, I'm giving a response to
Yes,
this.
yes.
The director will take the support of the district civil administration. Why civil administration? Because there will be a magistrate.
Hmm.
There will be a magistrate. The district administration,
Yes.
either the deputy commissioner himself or he will depute some lower level magistrate
Hmm.
with the police.
Hmm.
So the language is very clear.
Yes.
The director may, as and when situation so demands. Suppose I am running a school. I do not have any registration.
Hmm.
I do not allow any inspection to come.
Yes. Close it down. That's your right.
Now, close it down.
Suspend the
Close it.
recognition.
Close
That's
it.
the answer.
No, but before that, before closing, I have to submit a report to
Yes.
the government. Who will take the call? The government. Closing part is, lordship, the government will have to take.
Yes.
Pay section 24.
Recognition committee.
No, it is not. Section 24, may I place it?
Yes.
Where any non-government educational institution fails to fulfill or comply with the provisions of the act or violates any of the provisions of this act
Yes.
or the rules made thereunder, or any order passed by the state government or the director under the provisions of this act. The state government may at any time after giving reasonable opportunity of being heard, order for withdrawal of administrative recognition and closing down of the non-government educational institution. So it is not the director who will do it. It is the
That is
state
what
government.
we are saying, Ms. Saikia. For closure, the state government has to be approached, but the director can take police without any reason.
No.
There is no reason.
No.
Situations or demands. What is have you defined what is the situation? Is it at the whims of the director?
I'll place a judgment, Lordship. Now, all the situations cannot be completed when the legislation is made. There are certain areas.
When you
where
are dealing
there are
with an
gray areas.
educational institution, Mr. Saikia, it's an entirely, this is not a criminal activity which is going on. It's an educational activity,
Absolutely,
which
Lordship.
you yourself say it is a charitable activity. So why
Is it
involvement of
not
police?
common that police entered JNU?
There was an
The
offense
situation,
that was
situation
not,
demands.
that
If
was
the
not.
students and the owner becomes very.
Don't equate that situation. That was a situation wherein there was a hue and cry regarding
Lordship
the
does not.
country's integrity.
Lordship is not
They-
aware that Assam had a very bad history of students movement. And in some areas it was violent also.
Yes, all right. Anyhow, you make your response, whatever.
Yes, Lord.
We have given you your
The
opinion.
situation, it is not that in all cases, it is an exception. Why this provision is there?
Yes.
That the director, if he has been resisted from inspection or entering into a premise, first, the director will have to be satisfied that whether
This
that's.
act, this section doesn't say so. That is only in event of facing resistance that he
Yes,
will
Lord,
take police action.
some leeway will have to be taken, some application of mine will have to be taken, given.
Anyhow,
Yes,
all right,
Lord.
you continue with
Yes,
it.
I am continuing.
Yes.
So the management scheme has to be given, section 14. So I'm leaving that 2000, that fee
18 Act.
structure act now.
Yes, fee structure.
So the director may approve or disapprove the proposed increase in fees if he is of the opinion that such an increase is necessary due to increase in
Where
facility.
you are reading which provision?
Section 14
Of
3 of the 2006 act.
now, this is it not in conflict with the Act of
Yes, that
2000?
is why that addition. So this part, now cannot take any decision on his own.
This has to be deleted from this act. This part where fee structure is concerned, director would not have any role. You yourself read that provision, other than a
I have no
facilitator.
role. But if the management scheme is provided where the fees is given to be more than what the approved rate. Lordship will have to hear me.
No, we are hearing you. We are putting a query.
No, let me
You are
complete-
you
let me
yourself.
complete my sentence.
You yourself
Let me
said.
complete my sentence.
You
Lordship.
yourself read 2018. We are just discussing.
Yes.
You yourself said 2018. Entire part of fee structure is with the
Yes,
committee.
Now what?
Yes.
Let me reconcile it now with this.
Yes.
How it can be reconciled?
Yes, let's see that.
Yes.
Yes.
The fees committee will finally approve the. Just 1 second, Lordship.
Yeah, let's read the Act of 2018 again.
Yes.
Yes.
The committee will finally. Just 1 second.
Yes. Section
I'm coming.
powers and functions, section 8. Read section 8 of the Act of 2018.
Section 9. Lordship will kindly.
8,
Section 9.
first. 8.
Yes, powers and functions of fees regulation. Now, what will the outcome after taking all these factors?
Yes, what is the scheme of section 8? Read.
Okay.
Where is it in conflict with
No, it is
section
not
14?
in conflict.
Just read it first.
Subject to the provisions of section 10, the fees regulatory committee shall determine the fees payable by students in the non-government educational institution. The committee shall have the power to require each non-government educational institution to place before the committee the proposed fee structure of such school, along with all relevant documents and book of accounts for scrutiny before such date as may be specified by the committee. Verify whether the fees proposed by the non-government educational institution justified and whether it amounts to profiteering or charging of exorbitant fees. Approve the existing fee structure or determine the fees which can be charged by the non-government educational institution. Verify whether the non-government educational institution operating within the territory of the state of Assam is recognized by the competent authority of the state government or affiliated to the Assam Higher Education Secondary Education Council or Board of Secondary Education Assam or the CBSC or the ICSC or any other board constituted by the state or central government as the case may be, and the institution imparts instruction prescribed by the Assam Higher Secondary Education Council or Board of Secondary Education Assam or any board as referred to above, as the case may be. Hear complaints or initiate suo motu hearing with regard to collection of excess fees by a non-government education institution as referred to above in clause B. Regulate the fees charged by the school and panel action as per the provisions of this act. Report the matter to the state government for the institution.
Regulate the fees. You just look at this provision.
Lordship.
Regulate the fees, section 5.
Yes.
Charged by the fees. So the power of regulation is with this fee regulatory committee.
Yes, Lord.
Under the Act of 2018.
Yes.
How the
Now
director can do
I'm
it.
coming to section 9. How it can be reconciled?
Yes.
The fees regulatory committee shall recommend maximum limit of fees to be charged by different categories of non-government educational institutions every year before starting of the academic session, taking into account the accounts of the factors as mentioned in section 10, and the state government shall notify the same in the official gazette from time to time.
Yes.
So a particular fees has been
Structure
approved and
will
has
have to
been
be
notified.
notified. Yes.
Notified. Now, if coming to section 14 now of the 2006 Act, the director may approve or disapprove the proposed increase in fees if he is of the opinion that such an increase is necessary due to increase of the facilities provided, and may disapprove for reasons to be recorded in writing.
Would the fees, increase of fees not tantamount to revision?
Increase or decrease now, suppose is.
Answer the question, Mr. Saikia. Would the increase or decrease in fees not tantamount to revision?
No, here, that.
Yes,
Let me give my answer.
Yes,
It may not be acceptable to the honorable court.
Yes.
But suppose this committee, the fees regulatory committee fixes 100 rupees. And this scheme of management provides a scheme where the fee structure is 110. The director may say that the upper limit fixed by the committee is 110. So can you revise it and bring it to 100? Or suppose.
Yes.
Increase. Suppose for increase, I'm sure the director will never say that. Increase the fees. But if it is to be on the higher side, when there is a benchmark, the benchmark is 100 rupees. So if the scheme contains a fee structure which is 110 or 120, he can indicate it. This is how we can reconcile it. Or else if lordship feels that this can be removed.
This is
we have no
approaching
difficulty
upon
on
the
that.
sphere of the fee revision committee, which is headed by the High Court, retired High Court judge.
No,
plain and simple. Because this is increase. I don't know whether you can even argue that increase doesn't amount to revision.
No.
Increase doesn't amount to revision. If that is the argument, there's a different thing.
What we can say, lordship, what the director can say here, he can say only one thing, that your fees is not commensurating with the fees fixed by the committee. So you
The director is not required to apply mine. Mr. Saikia, after coming of the Act of 2019, director is not required to apply his mind to these things. He has no role. The role is specifically defined.
No, for every time this scheme has not to be submitted to the fees regulatory committee. These are two different areas.
Okay, very well. Carry on. Yes.
So now my humble submission is that if the scheme given by the school authorities, if it is not commensurating or it is not in tandem or not as per the prescribed rate fixed by the regulator, then he can indicate it. Because this scheme will never go to the fees regulatory committee. It will never go there. The act does not contemplate that the scheme of the management is to be placed before the fees regulatory committee. The fees regulatory committee will only see, this is only one part of the scheme. The scheme has other parts also.
We are talking about fees only, Mr. Saikia. We are asking you the query about only about the fees.
What I am
only about section 14.3.
I'm lordship, what I'm trying the role of the director in the act itself, because their whole thing is that the director is given excessive power.
That's what we are saying now after coming into force of 2018. Whether in the fee structure, director has any say. That is what we are asking.
No, he is a part of the committee. His role is administrative.
Under the Act of 2016, 2006, what powers are given? Are they not in conflict with the provisions of Act of?
In my humble submission, it is not.
Very well. Okay.
It is not.
Okay.
There is no conflict. And if it is conflict, that is taken care of by section That is the section 18 of the
Okay.
Fees Regulatory Act of 2016.
All right, okay.
Because save and otherwise provided in this act, the provision of this act shall be in addition to and not in derogation of any other laws for the time being in force. Both are state acts.
Okay, very well.
Then director's role further will be section 19. Provision of compulsory donations. No government education institution shall levy or collect any donation compulsorily from any students or his or her parents, guardians, provided that the managing committee with prior intimation to the director may invite voluntary contributions. So director, his role is that he can be intimated if some additional amount is taken. Now inspection, the director or any officer authorized in this behalf.
Yes.
584.
Lordship, before going there, I would like to place one particular provision of section 10, subsection 16.
Yes.
The institution shall be open to inspection by any of the following officers. Have Lordship got it? Page 584.
Yes.
Any officer authorized by the director, director of medical services or health officers of the local authority concerned, medical and health officer authorized by the appropriate authority or the director of to examine the health of students or sanitary conditions of the institution and surroundings. Amending 2 additional part officers were included. Executive engineer of public health engineering department or any other officer authorized by him to ensure providing potable drinking water facilities to the students of the institution. E, the district transport officer of the concerned district or any officer authorized by him to examine the conditions and roadworthiness of the vehicles used by the institutions for transportation of the students or for any other purpose. So director himself is not the sole authority. He can depute concerned officers who has a special expertise in a particular area. If the school building has to be checked, director is not the competent person. For that, the PWD engineer is required. So this amendment of 2018 inserted 2 officers. Executive engineer, the public health is there. Public works department was also there in another in the definition. In the definition at 2 Roman 5, executive engineer PWD building, he is also a prescribed officer.
Page 585.
585 page number. Lordship will kindly come to 12. Sanitary.
86 next page. Municipality support.
Sorry, 586. 586 20 subsection 20 B and C. In case of institutions situated in municipal towns, institution must obtain and possession of a certificate from the municipal board committee concerned to the effect that the building and classrooms have been constructed conforming to the building bylaws of such municipal board and town committee. In rural areas, a certificate from executive engineer PWD under whose jurisdiction the school falls. So when the certificate has to be issued, the executive engineer has to inspect the building. And Roman A says, all non-government education institutions registered under this act shall provide adequate safety measures, including fire safety measures of the institution premise, and shall hold mock drills for preparedness for the meeting of any disaster at regular interval. The school must have disaster management plan for it and duly published, and the school authority should hold periodic review of the plan so that prepared and published. A certificate from the disaster management authority shall have to be furnished as regards availability of adequate safety measures, including fire safety measures in the school. So various officers from various fields are included in the inspection part. It is not that the director he himself can do it or he himself is competent to do it. He, in my humble estimate, is not competent.
Yes.
So therefore, the inspection says the director or any officer authorized in this behalf may enter at any time with or without notice any place or building or premise which he has reasons to believe is being used as non-government educational institution. This is the area of concern, Lordship.
Yes.
May I read it once more? At any time, with or without notice, any place or building or premise which he has reasons to believe is being used as non-government educational institution. So he will have to first satisfy that whether a school is functioning there or not. If there is resistance, definitely, Lordship, he will have to take support of the police and the district administration or deputation of a magistrate.
Yes.
To make such examination of place, building, premises, or inspect any place, building, or premises, equipments, articles, etc. 3C. After making the inspection, the director or his authorized officers carry out the inspection shall furnish a copy of the inspection report to the manager or managing committee of the non-government educational institution to act upon the report and for compliance thereof. So his role, so far as inspection and supervision is concerned, is that he have to finally prepare a report and submit it to the school authority. That these are the deficiencies or these are the loopholes which you have to rectify. Then utilization of fund, there is nothing the role, there is no role of the director. Coming to section 22. Audit and accounts. The accounts of the non-government education institution shall be maintained and the audit shall be done in such manner as may be prescribed. The institution shall furnish to the director an audited statement accounts as at the closing of every financial year, mention clearly the total receipts and expenditures during the last financial year. So the institution will have to furnish the report. There is no role, they are more than that. You have to receive. Then regarding list of properties, section 25, here the list of properties has to be furnished to the director. Regarding withdrawal, the director, etc., cannot take the final call. It is the state government, section 24. Now, section 28. Delegation of power of the director. The state government may, by order, delegate any of the powers of the director under this act to such other officers as may deem fit and necessary. So it is not that the director only is the officer, the state government can depute another person also.
Yes.
Then appeal provision is there. I'm not on that. Now, coming to the judgment. In case if any excessive power is given, what the authorities may do and how to yes, 2000 volume 7 SCC page 425. 2000 volume 7 SCC mo heri kon na mo print out. 2000 volume 7 SCC page 425. Consumer Action Group and another versus State of Tamil Nadu. There are two petitions. Because their challenge is that excessive power and unguided power is given to the director. So to counter this argument, Lordship, I have placed whatever I have just completed placing. Now I am taking help of this authority. Paragraph 2. The petitioner through this petition under Article 32 of the Constitution has brought to the notice of this court the impunity with which the executive power of the state of Tamil Nadu is being exercised indiscriminately in granting exemptions to the violators violating every conceivable control check, including approved plan in violation of the public policy as laid down under the Act and the Development Control Rules. The submission is granting of such exemption is against the public interest, safety, health and environment. To bring home this indiscriminate exercise of power, reference is to be made to 62 such orders passed by the government between periods so and so, which has been annexed compositely in Annexure 2. Submission is, it is this indiscriminate exercise of power which results in the shortage of water, electricity, choked roads, and ecological and environment imbalances. So and so learned counsel for the petitioner submitted such exercise of power is because there are no guidelines or control under the Act. This is the main plank of attack for declaring Act Section 113 as ultra virus, as it can do or undo anything under the Act to wipe out any development without any check, which amounts to delegations of the by the legislature to its essential legislative power. Paragraph 8. Strong reliance is placed by the petitioner in the case of A.N. Parasuram versus State of Tamil Nadu, where Section 22 of the Tamil Nadu Private Educational Institutions Regulation Act 1966 was challenged. This conferred wide exemptions powers on the state government to exempt any private educational institutions from all or any provisions of the Act. The court held the provisions of the Act indicate that the state government has been vested with unrestricted discretion in the matter of the choice of competent authority under Section 2C, as also in picking and choosing the institutions for exemption under the Act under Section 22. Such unguided power bestowed on the state government was struck down as offending Article 14 in the case of West Bengal versus Anwar Sarkar. A similar situation arose in so-and-so case, wherein Section 4 of the Travancore Cochin Land Tax Act 1955, all lands were subject to the burden of tax, and Section 7 gave power to the government to grant exemption from the operation of the Act. The section was declared ultra virus on the ground that it gave uncanalized, unlimited, arbitrary power, as the Act did not lay down any principle or policy for the guidance for exercise of the discretion in respect of the selection contemplated by Section 7. Section 22 was held to be ultra virus as the Act did not lay down any principle or policy for guidance to the delegate for exercising this discretion. My attempt of placing the acts and the rules was that our power given to the director is totally guided, totally channelized within four corners of the parameters given of the rules and the Act. He will have to act. He cannot go beyond the provisions, beyond the prescribed limits given under Act as well as the rules. And also he cannot violate the objective of reasons and objects of the Act.
Yes.
Coming to page 436. I'm reading this section 7 of a particular Act. This court with respect of Section 7 of the Act held, furthermore, Section 7 of the Act quoted above, particularly the latter part, which vests the government with the power wholly or partially to exempt any land from the provisions of the Act, is clearly discriminatory in its effect and therefore infringes Article 14 of the Constitution. The Act does not lay down any principle or policy for the guidance of the exercise of discretion by the government in respect of selection contemplated by Section 7. Section 7 was held to be ultra virus as the Act did not lay down any principle or policy for the guidance. Paragraph 13. I'm reading one line, Lord. One line in the second paragraph, last paragraph. A legislature, have Lordship got spectrum above G. A legislature, while legislating, cannot foresee and provide all future contingencies. So this is my submission also, that certain areas we did not contemplate in 2005. So therefore, the amendment had taken place in 2018. If certain things come up during these deliberations also, we are going to do it in 2023 or 2024. But all the situations cannot be contemplated at the very beginning. When the situation arises, accordingly, it has to be molded. So here the legislature, while legislating, cannot foresee and provide for all future contingencies. Now coming to paragraph 15. In Sardar Inder Singh versus State of Rajasthan Constitution bench, this court was considering Section 15 of the Rajasthan Protection and Tenants Ordinance 1949, which with similar provisions authorize the government to exempt any person from the operation of the act. This court held a more substantial contention is in one based on section 15, which authorizes the government to exempt any person or class of persons from the operation of the act. It is argued that that section does not lay down the principles on which the exemption could be granted, and that the decision of the matter is left to be unfettered and uncanalized discretion of the government, and it is therefore repugnant to Article 14. It is true that the section does not itself indicate grounds on which exemptions could be granted, but the preamble to the ordinance sets out the sufficient clearness of the policy of the legislature. And as that governs section 15 of the ordinance, the decision of the government thereunder cannot be said to be unguided. So if the act does not provide also, if the preamble lays down the policy in very clear manner, Lordship, then that policy has to be taken forward by any action to be undertaken by any of the delegates of power under the act. 18. The catena of decisions referred to above concludes unwaveringly in spite of a very wide powers being conferred on the delegate, that such a section would still not be ultra virus if guidelines could be gathered from the preamble, objects and reasons, and other provisions of the act and rules. In testing the validity of such provision, the court have to discover whether there is any legislative policy, purpose of the statute, or indication of any clear will through its various provisions. If there be any, then this by itself would be the guiding factor to be exercised by the delegate. In other words, then it cannot be held that such a power is unbridled or uncanalized. The exercise of power of such delegate is controlled through such policy. The fast changing scenario of economic, social order with scientific development spawns innumerable situations which the legislature could not foresee. So the delegate is entrusted with the power to meet such exigencies within the inbuilt checks or guidance, and in the present case to be within the declared policy. So the delegate has to exercise its power within the control path to subserve the policy and to achieve the objective of the act. A situation may arise in some cases where strict adherence to any provisions of the statute or rules may result in great hardship in a given situation, where the exercise of such power or exemption is to remove this hardship without materially affecting the policy of the act, namely the policy of the act, namely the development in the present case, and such excess as hardship of any individual or instantly in the interest of society at large. Such power is meant rarely to be used. So far as decision relied on by the petitioner, where the provisions were laid to be ultra virus, there are held to be ultra virus as there was no principle or policy laid down. In this background, we find the preamble of the act laid down, an act to provide for planning and development and use of rural and urban land in the state of Tamil Nadu and for that purpose connected thereto. Paragraph 21. Not only preamble and objects and reasons of the act clearly indicate its policy, but it is also revealed through various provisions of the enactment. Section 13 of the section 2 defines development for carrying out any of the works contemplated in the regional and master plan, etc. Section 9 defines, etc. These are the provisions of that. Paragraph 22. There is a clear distinction between a provisions to be ultra virus as delegation of power being excessive and the exercise of power by such delegate to be arbitrary and illegal. The power is given to the director lordship to take police, the help of police as well as the district administration. If he is misutilizing that power to take revenge, to be vengeful for a particular institutions, that will be an arbitrary action on the part of that particular gentleman who is manning the post of director. But by itself, it cannot be said that the whole provision is ultra virus, because the power is given to him in extraordinary situations in situations which is not in normal circumstances take place, in given situation, Lordship, he has given the power to call the magistrate as well as the police to help him in the part of his inspection exercise. If he is wrongly doing it, then that will be an arbitrary action, that will be a vested interest, that will be governed by various other factors, which cannot be termed as bona fide.
Yes.
For malafide intention, he can misuse it, but that will not make the provisions of the act ultra virus.
Yes, carry on, carry on.
No, something is going.
Doesn't matter. Please.
Yes.
We are not hearing anything by virtue. Mr. Zakir, let it be. Doesn't make sense. Yes.
Paragraph 23. Submission is that the government has exercised this power of exemptions indiscriminately contrary to the provisions of the Act and rules. Now coming to next page, Lordship. The last paragraph, first line. Each of these orders reveals non-application of mine by giving a total go by to the rules relating to the restriction and control in construction of building, etc. Last 4 lines, Lordship. The submission on behalf of the state for salvaging the validity of section 13 being ultra virus was that the government does not possess uncanalized and unbridled power as it is controlled by the policy of the act. The question is whether the impugn orders could be said to have been passed for furtherance of such policy or for achieving the purpose for which it is enacted. So even as submission, it can be exercised in the act in the aid of such policy and not contrary to it. We find in the present case, the government, while exercising its power of exemption, has given a go-by to all the norms as laid down under the act and the rules, and has truly exercised its power arbitrarily without following any principle, which could be said to be furtherance of the objective of the act, nor could learned counsel for the state point out any. 29. When a statute confers any power or on any statutory authority, in our case, it is a director. When any statute confers any power on any statutory authority, including a delegate under a valid statute, howsoever wide the discretion may be, the same has to be exercised reasonably within the sphere that the statute confers, and the such exercise of power must stand the test of judicial scrutiny. If he is misutilizing his power for the timing, Lordship, he is always subjected, his action is always subject to judicial scrutiny. But we cannot prejudge that he will do wrong thing. Sometimes for genuine reasons, he can take the police or the help of the magistrate. This judicial scrutiny is one of the basic features of our constitution. The reasons recorded truly discloses the justifiability of the exercise of such power. The question is whether the power has been exercised validly by the delegate in the present case. If yes, then it can only be for the furtherance of the policy. But what is that policy? The policy is the development and use of rural and urban land, including construction of colonies, building, etc., in accordance with the policy of the planning as laid down under the Act and rules. When such a wide power is given to any statutory authority, including delegate, then it is obligatory on the part of such authority to clearly record its reasons. In all the reasons, Lordship, the decision of the director, he will have to pass an order by justifying in writing.
Okay.
Record its reasons in the order itself for exercising such power. Application of mind of such authority at that point of time could only be revealed when the order records its reason. Even if the section is silent about recording the reasons, it is obligatory on the government while passing orders under section 113 to record the reasons. The scheme of the act reveals that the government is conferred with wide-ranging power, including power to appoint all important statutory authorities, appoint director and members of town and planning under section 4, constitute Tamil Nadu, etc., etc. The government entrusted for making master plan and also new plans, any plan or modification is subject to approval of it. In fact, every statutory committee is created by the government and its planning is subject to the approval of the government. It is because of this, the very wide power given to it under section 113. In a given case, when a new development in a rural or urban area may be required urgently and provisions under the Act and rules would take a long procedure, it may, in exercise of its exemption, power exempt some of the provisions of the act and rules to achieve the developmental activity faster and in a given case, if any hardship arises by following or having not followed the procedure as prescribed, the power of exemption could be exercised. But each of these cases would be for furtherance of the development of that area. When such a wide power is vested in the government, it has to exercise with great circumspection. Greater is the power, greater should be the caution. No power is absolute. It is hedged by the checks in the statute itself. Existence of power does not mean to give one on his mere asking. The entrustment of such power is neither to act in benevolence nor in extra statutory field. Entrustment of such power is only for the public good and for public cause. While exercising such power, the authority has to keep in mind the purpose and policy of the act, and while granting relief, has to equate the resultant effect of such grant on both the public and individual. So long as it does not materially affect the public cause, the grant would be eliminate individual hardship, which would be within the permissible limit of exercise of power. But where it erodes the public safety, public convenience, public health, etc., the exercise of power could be for furtherance of the purpose of the act. Minor aberration here and there to eliminate greater hardship may be in a given case be justified, but in no case affecting the public at large. So every time the government exercises power, it has to examine and balance this before exercising such a power. Even otherwise, every individual right, including fundamental right, is within the reasonable limit. But if it makes inroads to public rights leading to public inconvenience, it has to be curtailed to that extent. So no exemption should be granted affecting the public at large. Various development rules and restrictions under it are made to ward off possible public inconveniences and safety. Thus, wherever a power is to be exercised, the government must keep in mind whether such grant would recoil on the public or not, and to what extent. If it does, then exemption is to be refused. Coming to paragraph 31. We find in the present case, under the garb of wide power, it has exercised it illegally and arbitrarily beyond its power vested under the said section without application. And all these orders were set aside, 62 number of. But their case is that they have deviated from the norms set in the act.
Yes.
The purpose of the policy is also deviated. So in that case, Lordship, the judicial scrutiny is there, and there is always scope for interference. And ultimately, the legislation was upheld. Here also, Lordship, my humble submission is that whatever power is given to the director,
yes,
everything is to be exercised within the norms set in the act as well as the rules. He cannot do anything on his own whims and fancy.
Yes.
The scheme under section 14, there's a rule. That rule, Lordship, I'd like to indicate that's management scheme. How the management scheme, in what area he will have to look into. The management scheme he can approve or disapprove, but if it is within the parameters of the scheme of management under section 14, rule 16 of 2007 rules.
Yes.
Each and every non-government education institution shall prepare and submit to the director a scheme of management with the following provisions. Power and functions of the chairman, secretary, etc. of the institution. Procedure to be followed for constitution of the managing committee. Powers, functions, tenure of the managing committee. Procedure for selection, appointment, promotion, and teachers and non-teaching staff. Qualification of teachers and non-teaching staff. Salary structure for teaching and non-teaching staff. Service conditions of the employees, code of conduct of the students, manner of supervision, guidance and control of teaching and non-teaching staff. Their manner, not the manner of the directorate. Students' fee structure indicating rate of admission, tuition fees, game fees, etc. as per student class wise. So here, procedure for admission of students and provisions for concession exemption of fee to any students. Manner of collection of voluntary contribution from the parents, guardians, as under section 19. In section 19, the director has to be intimated. Procedure for taking disciplinary action against students. Provisions for professional development of teachers. That is a training program for the teachers. In the CBSE also that is mandatory. Provisions for contributory provident fund, employees provident fund, welfare scheme for teaching and non-teaching staff. So these are the 15 parameters in which the scheme has to be submitted. If he asks for the 17th one or 18th one, that will be beyond the scope of the act and the rules. That is not permissible. If he demands certain things from the school management committee, which are not indicated here, that will amount to exercise of uncanalized power, unbridled power, unguided power. Here, everything is guided.
Yes.
So it is, may I continue or stop, Lordship? It is 1 o'clock.
We'll have to continue on Monday.
Lordship.
Our hearing continues. List on 28 for further hearing. Other matters discharged. Yeah, let the office fix dates. Yes.
Highly obliged.
May I please, your Lordship?
Yes.
Lordship, I mentioned item number 8, my lord.
Yes.
In item 8, my lord, we had filed an affidavit yesterday, my lord. It is not on record and quite voluminous, my lord.
Okay.
11, my lord.
What is the matter about?
11, my lord, that Rehin Parka issue, my lord.
Okay.
Item number 11.
11.
Not 8.
11.
11, my lord.
That illegal mining, my lord. That, my lord. They have filed a affidavit yesterday.
Okay.
We had filed a consolidated affidavit, my lord, quite voluminous, my lord.
You got a copy?
Yes, I have got it.
11.
What is required to be done then?
But it probably it does not mean, my lord.
It will have to be
Some
called.
other day, my lord, I have to go for it, my lord. It's a very voluminous, I have to go.
All right, affidavit on the forest department has been filed yesterday. The same be brought on record. The Nedemitis, Mr. Mahanta, senior counsel, Mr. Mahanta, seek praise for time to go through the affidavit and respond if so required.
My lord.
Please notify on 5th October.
My lord.
All of them.
Daily list for orders, item 1 to 3.
In item number 1, we have filed one detailed affidavit and proposals of our plans, Lordship.
When did you file it, madam?
We have filed on 19th day of June 2023, Lordship.
That is already on record.
Yes, Lordship.
Respond affidavit by R2.
Yes, Lordship.
R2, that is there on record. Yes.
One or two.
What have you said in that affidavit? Affidavit shown by Hemanta Bhuyan. Right?
Yes, yes. Dim, sir.
What do you say, madam?
I'm in item number 2, my lord.
Who's there in item number 1?
Sorry.
I have been served with the copy of the affidavit.
You have not received?
And I have received. Madam, nice things are written. The problem is not never with the projects, problem with their implementation.
Then you have to counter that, sir. They said that they already implemented. If you have got any material to counter that, then
No, so
why
far as
should we?
so far as the garbage dumping ground in Dibrugarh is concerned, that has been shifted.
Okay.
That has been shifted.
That was the basic prayer in your writ
That
petition.
was my basic prayer.
We expanded it later on.
But the earlier ground also not that much of, not cleaned up that nicely, my lord. Anyway, the garbages were shifted and they have gone to downstream Brahmaputra on the bank of river Brahmaputra to my instructions. But the question is, shifting the garbage dump from this place to that place, whether
They have also,
that will be.
they have, Mr. Barbara, they have also mentioned in their affidavit regarding their plans for solid waste disposal.
I've seen that.
That is the main thing. Main issue to be addressed is solid waste disposal.
Yes, ma'am.
So I mentioned certain facts in their affidavit regarding that also. What do you have to say on that?
No, I say, my lord, they have said that about various projects, Lordship will query them, my lord. What is the stage of implementation in public interest? Not only in the interest of my client, my lord.
And of course, that's why we expanded the scope. Mr.
And
Purva.
there is already a notification by Government of India about climate change and, my lord, forest and environment. So naturally, the state of Assam is also should be bound by that. and
Madam,
should take steps. They are-
in order dated 18th May, we had been informed by you that there's a policy being prepared for disposal of garbage and recycling of solid waste. What has been done in that regard? Where is the policy? Is the policy in place? Because see, creating landfills is not the answer. When an Advocate General was appearing in this matter earlier, what happened? Any specific plans for disposal of solid waste? That was the concern we had shown.
Landfill is not one part.
Landfill is not the solution. It can never
Only
be.
one part.
That creates more problems. Disposal of solid waste. What is being done for that? Earlier occasion, Madam Boda appeared on your behalf, Ms. Saikia. What happened now?
I appeared because it was not informed to me today. That's why I could not go to it.
On 2 dates, it has been informed that she has been appearing on your behalf. 26th
No, no,
July also you appeared.
Last date I appeared, Lordship, in this.
Last date you appeared.
Just now I have come to know that this matter is about.
We'll pass it over. Just have a look at it.
Yes, yes.
If there's anything which has been done regarding the solid waste disposal, please let us know.
Yes, Lordship.
There are some documents
It
placed on
will be
record.
taken up after little bit later.
Yes, we'll pass it on. So 1, 2, 3, pass on.
Please concern, same issue, Milord, with regard to Nagaon, Milord. On the last occasion, Mr. Nayak appeared for the state respondent and placed before the court that initially the Nagaon Municipal Board, Milord, initiated the proposal along with the monetary sanction and all. Thereafter, the submission was made that Pan Assam, Milord, projects are coming up for solid waste management.
That is what the affidavit is there in item number 1.
Lordship.
That affidavit, probably you will require a copy of that affidavit. Will be better. Mr. Nayak, the affidavit, detailed affidavit which has been filed in item number 1. Lord, serve a copy to him. Lordship. Okay, with that. Pass over. Pass over.
My lord.
May I please your lordship, in item number 2, our prayer was for shifting of the garbage yard, Sipsagar garbage yard.
in respect of Sipsagar town.
So what has been done in that regard?
They have submitted a DPS, but DPR, but I haven't received the copy as yet. So shifting for that, government has allotted land also separately.
Who is there in this matter?
So I am for a Sipsagar municipal board, my lord, he is representing Assam, my lord.
But you must be knowing, the municipal board must be knowing the status of the garbage dump.
No, garbage down, my lord, existing down is, my lord, we are maintaining and improving, but regarding shifting, my lord, probably they say that they have invited tender.
No, still, my lord, awaited, but this is a financial approval is there, my lord. We are waiting for financial approval. Matter is pending before Delhi.
Before?
Of central government for financial approval. Not only in Sipsagar, not only Sipsagar, in all district of Assam, that project will go, my lord.
Under central funds?
Yes, my lord.
Which scheme?
This is scheme, my lord. Swachh Bharat.
Swachh Bharat. All right. Okay, let's take it up after a while.
Yes.
Next.
Item number 4.
My lord, as per last order, your lordship was pleased to direct central government to release fund, your lordship, and file affidavit to that effect.
Yes.
My lord, though I could not file the affidavit, I have received some instructions regarding release of fund.
Documents.
In second para, my lord, fund will be released on receipt of requisite document from the state government. They have asked the state government to submit a document, my lord, but central government did not receive any document.
What documents are required?
My lord, these are the documents. Ma'am.
Have you given a copy to the state council?
Yes, I.
Why the state authorities have not forwarded?
Here, my lord, in my email, my lord, that Roman 1, 2, 3, 4, 5, 6, 7, 8, my lord, latest QPR for the quarter ending June 2023. UC for release of matching state tier, latest inspection report with date, rescheduled date of completion, revised work plan for balance work of the project, zero balance certificate and zero balance subsidiary account detail of the MPD.
This is a project of 2008,
Yes.
and we are now harping on the QPR for the quarter ending 2023.
Yes, ma'am.
It's just a matter of shifting the burden or nothing beyond that. Passing the buck, that's it.
Fund is to come from donor ministry now.
Yes, ma'am.
Donor
From donor
ministry is not a party here.
But as per instruction, my lord, documents are required.
Obviously. You'll have to complete that ministry, gentlemen.
Ma'am.
This.
Miss A. Gayan has produced a copy of the written instruction dated 21/3/2023, issued by the Honorable Secretary to the Government of India, Department, Ministry of Donor. A perusal of which goes to show that necessary funds for completion of the project within quotes augmentation of greater deep water supply scheme in Karbi Anglong district, bracket Karbi Anglong, bracket close, unquote, is under consideration of the donor ministry, and the funds will be released on receipt of certain documents called for from the state. First of, Ms. Gayan has also produced the copies of emails by means of which certain documents have been called for. However, it is not clear as to why those documents could not be furnished to the donor ministry. You are appearing for donor.
You will be appearing for the donor also. You know,
Yes, I'm appearing from donor, my lord.
Already
That is
appearing.
the instruction of donor, my lord.
So there is no need to implement donor separately.
No, not to implement, my lord. We are already party in that case.
Now,
yeah.
who is for the state of Assam? What has happened? These documents.
This is fresh come on today. This has been produced, man. We have to check and take instructions.
This is 2008 scheme, gentlemen.
Yes, ma'am.
In 2023, this still matter is going on for exchange of documents.
No, man, it was a transfer subject. Initially, prayer was not against us. We had the major role. Today only itself, it has been revealed that we have this kind of role.
The letter says that state equals shares to be borne by the state.
That is, madam, that was, initially it was not a, prayer was totally different. We are not in a session of the matter, madam. Now, today also only it has been pointed out. So we will get some time, madam.
In view of the request made by Mr. D. Govill, Understanding Council, PhD Department, as we adjourn this matter till 5th of October 2023, so as to enable the state to forward all requisite documents to the donor ministry. The action taken in the matter be placed on record in the form of an affidavit on and before the next meeting. This again on file.
Madam Gayan, maybe request,
Yes,
maybe.
ma'am.
Give a copy.
Yes, ma'am.
Madam, date, madam, which?
5th October.
5th October.
Item number 5.
Can I give your lordship?
Yes.
Lordship, in this matter, I'm still awaiting my instructions, your lordship. This is regarding artificial floods caused by land filling. There are various revenue circles mentioned, your lordship. That's why it's taking some time, your lordship.
Council members, board by appearing for the response numbers 1 and 2. You will be appearing for
1 and 2. My lord, I'm appearing for response number 6, my lord.
6. What about the response numbers 4 and 5? Then Advocate General appeared on the last date. Anyhow, pray for and are granted. Time to file affidavits on behalf of the respective authorities. List on 5th October.
6th of
5th.
I'm deeply obliged, Your Lordship.
Item number 6.
May it please your lordship.
What is subject matter?
Your lordship, the issue raised in this PL is that the Excise Department has violated Article 40A of the Constitution of India by introducing an excise plastic sticker pasted in the mouth of each and every IMFL bottle, your lordship. Now, what is this plastic sticker, your lordship? It's termed as holographic excise adhesive label, your lordship. In short, it is known as HEAL, HEAL. The HEAL sticker is firstly introduced in the state of Tamil Nadu. And now almost 17 states in Union of India, and including the state of Assam, is using this sticker, your lordship. The subject matter of this PL is not regarding the use of HEAL, your lordship, but the material used to manufacture the sticker labels, which is a banned plastic in the state of Assam. Unfortunately, the Excise Department is allowing manufacturers.
How do you say that it is banned? What is the material placed on record to support this contention?
Your lordship may kindly come to page number 28, your lordship. This is the notification dated 10/7/2019, your lordship, issued by the Additional Chief Secretary to the Government of Assam, Environment and Forest Department under order of the Governor of Assam, your lordship.
Which clause of this order you are relying upon?
Your lordship, page number 28, annexure 2, your lordship.
Yes, which clause of this order you are referring to? As per you, under which part of this order is being offended by this sticker?
Lordship, on the 4th part, your lordship, may I read, your lordship? With a view to prevent the recurrence of such problems, the state government, in exercise of power conferred under Section 5 of the Environment Protection Act 1986, Central Act 29 of 1986, in accordance with the power delegated to the state government of Assam under Section 23 of the said Act by the Ministry of Environment and Forest Government of the India, notification number so-and-so, dated 10th February 1988, the Department of Environment and Forest Government of Assam has imposed ban on single-use plastic by notification dated 29th April 2019. This is the notification issued by the Environment and Forest Department, lordship.
The biggest things, just the you notice to the respondents.
My lord, I had something to say, my lord. The same document which it relies on, my lord, it is a multi-layered, my lord, and multi-layered is exempted, my lord. That same notification, my lord.
How do you say that it is multi-layered?
My lord, because
This sticker is a multi-layered sticker.
It's multi-layered because, my lord, it's a hologram. It contains a QR code, my lord. Also, my lord, the sticker is there.
You satisfy the code that the hologram is made of multi-layered plastic?
Yes, it's multi-layered, my lord.
Not on your saying, satisfy us by proper
That
material.
particular, he's not agree because we have been using IMFL bottles are being 99% bottles are plastic caps, my lord. He's not agreed by that.
Not caps, gentlemen. The
Yes,
issue
my lord.
is,
Exactly, my lord.
Mr. Gogoi, the issue is that these kind of plastics And likewise, Bombay has been facing a big problem. These milk pouches, plastic milk pouches, the corners are cut, they completely choke the drains. The small pieces of plastics, they fly away anywhere, then they immediately enter the drains. So that is the reason why he has come up with this. File your response, we'll see. If it is not private, not having it in the domain of that notification,
Yes,
will not consider his prayer.
my lord.
Mr. Gogoi appears for so and so. Who is appearing for the excise?
I am for the excise, man.
You are for the excise, all right. Copies of the petition be provided to the standing council for appearing for the respondents. Who pray for and are granted 6 weeks time to file affidavits on behalf of these authorities. Re-notify on 5th October. You'll have to serve the respond numbers 6 and 7. You are appealing 6 and 7 only. Pollution control board is 167. Okay, 167.
Item number 7.
May please, your lord. No, this is with regard to conservation of the Borolu River, cleaning and conservation. Lord, on the last occasion, my lord, I made a request before your lordships to bring on record this report I have just given, my lord. This is a report prepared in pursuance to direction of the Green Tribunal. Members are, my lord, Secretary, Environment and Forest, Urban Development Department.
Yes.
So it deals with the various issues, my lord. I'll just take your lordships with this some primary issues. Lordship will kindly turn to internal page 10. Down below page number is given. First, I'll just take your lordships with the main points, my lord. Para 6.3. Down below is the page number.
Yes.
Para 6.3, my lord, identification of towns for
Everything we got. Yes, yes.
well, identification of towns for installing sewage system and sewage treatment plants. The committee considered and as recorded as per the survey done, 3 STPs has been proposed at Guwahati city in consultation with the district administration. Next page, my lord, will find the 3 STPs wherein it was proposed. Then
these are still proposal in
yes, the
the stage of proposal only.
Yes, these are yet to be implemented. This committee was, my lord, this report was of 23/7/2019. And there are various suggestions also in this report. And those will be very beneficial, my lord. Then in the same page 11.
You have prepared the report?
No, my lord.
Then
I got it, my lord. I just produced before your lord.
Where from? River Rejuvenation Committee?
Yes, my lord. It's
This is committee formed under any statute or what?
This was, my lord, pursuant to direction of Green Tribunal.
NGT.
Okay. This committee was formed and this committee, my lord, this report prepared this report. So the committee comprises of Secretary to the Government of Assam, Environment and Forest Department, then Secretary, Urban Development Department, then Commissioner, Industries and Commerce, and Member Secretary, Pollution Control Board. Last page of that report, you'll also find the members. Then the suggestions are also there. Then para 6.4, page 11, water quality of the river stretch. There is one sampling station of Borolu River at Guwahati Metro District under NWMP as per the following. You know, the water quality of the river, the details are also given in the next page, page 12. Then
they're at table number 6.
Yes.
Hardness, calcium. What about, do they look at E. coli also, coliform?
Yes.
300.
Yes.
Fecal coliform, 4200. This is what I was expecting. Last date we requested you to get test reports.
Yes, Lordship, we have collected 10 samples from 10 outlets. from where the river Brahmaputra is getting the, then we have submitted to Pollution Control Board. I have received a letter of 18th October, 18th August, Lordship. They are requesting 5 more days. So 5 more days is going to be over today or tomorrow. We are awaiting the report.
We'll post this matter as an exception in the next week. We
Lordship.
need to see those reports.
Lordship. We have collected it from
You
10
have got a
places.
copy, you have received a copy of this report.
Yesterday night it was given to us.
So this report by the committee,
Yes, Lordship.
this has given very valuable suggestions.
Absolutely.
So what would be the, because state is a part of this committee.
Absolutely. Lord. The Dohua is also there, forest is also there.
Yes.
And already certain actions are already taken, not STP.
STP, the proposal since 2019.
What we are doing, that part may not be accepted here. The river has been cleaned, the embankment has been all concretized.
Have you seen that area at Baralumuk? You see it clear.
The end point, mouth.
Yes, mouth. It's full of garbage every day.
Lordship.
There has to be an
Large
round
scale
the clock.
encroachment, we are removing the encroachments now. That process is going on.
Not about the encroachment, gentlemen, the garbage in that spot. That is an encroachment by dirt. For which there are round the clock mechanism has to be there. Otherwise, those plastics will flow into the river.
Lordship.
So instruct the authorities today itself
Lordship.
that there has to be a continuous mechanism to remove that collection
Lordship.
and proper disposal. Can't be to take it out and throw it elsewhere. That will not serve the purpose. That will be a disastrous action. So that 5 days time, you said
It is to be over today.
today. And your response to this action, suggested action plan?
We will respond, Lordship, because it was supposed to be given the other day. The matter was last fall. It was given last night only.
Yes. Mr. Das has presented a report annexing therewith a action plan prepared by the
committee
river government of Assam, river rejuvenation committee consisting of 4 members. That is secretary to the government of Assam, so and so. नाम लिख देना इनका. The learned advocate general submits that the state government is cognizant of the suggestions given in the report and that he would like to respond thereto in a short period. He further submits that the samples of water in terms of the directions given on 26/7/2023 have been collected and have been forwarded to the Pollution Control Board for analysis. The report is expected shortly hereinafter. Re-notify on 30th August at 4 p.m.
Deeply obliged.
Item number 8.
Nothing, this matter, Millard, I need some time to go through the affidavit. Yesterday, Millard, the state has filed an affidavit in response to the affidavit filed by the central government. Some time will give, Millard, I'll compare both and I'll come up with my stand, Millard.
Mr. Das, praise for and is granted short opportunity, granted opportunity to go through the affidavit filed on behalf of the state on 23rd August 2023 and to respond, re-notify on 5th October.
My lord. Highly official.
Item number 9.
May it please the Lordship. This is the report where Lordship had given some guidelines and suggestions. So the government was
Government is supposed to respond.
Yes, Lordship, we have filed an affidavit. We have taken note of all the suggestions and the process has started for its timely implementation.
Okay.
The first demarcation has to be taken, all this.
That will take time. Nobody
It will
can
take
dispute
time.
about
The
that.
process
It's
has
not an
already
overnight thing. And it has to be done with all care and caution, no doubt. about that.
First, the boundary has to be properly demarcated.
You filed an affidavit on 23rd August.
Yesterday.
Yesterday.
We have not got a copy.
Can we see, Mr. Saikya, what have you said in the affidavit?
This is just a general thing that we have taken note of it and we have already
started the process.
Yes, Lordship.
Okay. This is the affidavit. It's there on the record.
This is by the forest department. I have received information from the GMC also now. The GMC also, GMC's indication that a proper agency may be directed by this honorable court. This is GMC's stand.
You let us know. You give the
Yes.
suggestion.
Which will be the best agency?
Yes.
There should be a nodal agency, Lordship.
Obviously,
Yes.
there has to be.
So I'll come up with that.
Then we'll fix this one also on 30th.
On
On 30th.
30th.
Well, one suggestion. The Lordship will take up two orders of the Lordship dated 25/5/2023. Because the entire thing is revolving around the eco-sensitive zone. Now the central wetland rules cannot operate. The Lordship had passed an order on 25/5/2023, where the learned advocate general submitted that a detailed report on the eco-sensitive zone will be placed. And Lordship, again, your Lordship will take up the dated 15/6/2023. But information is that till now, the government will have to give the report as to whether they have notified, because the submission was made that on 21/6/2023, the eco-sensitive zone, the central government had already considered approval. Well, that part has to be there. Because ultimately, the 2017 wetland rules will give the community rights and everything will be included. And there cannot be any solid waste areas in
Discharge
that
into that,
dumping areas, because there is a prohibition. So, and two departments affidavit will be very necessary. The matter being an inquisitorial litigation, the other one is by the Pollution Control Board, because I have information that the Pollution Control Board has taken report from the waters of Deeporville and found out that the oxygen level is depleting. The fishes are there.
That was when the water level was low.
Yes.
Later, the oxygen levels have increased with the rise in the level.
Since we have made them a
That
party-
issue we have addressed in the order.
Yes, well,
Previous
since we
order
have
that-
made them a party, they should also play, because my learned friend, Mr. Bolwa, is there.
Yes,
He assured me that. he's
Affidavit on
filing
behalf of
affidavit.
the Pollution Control Board.
We haven't filed yet.
You have to file it.
Yes.
What are you waiting for?
And
Any green signal from anywhere or not?
And also the Water Resources Department, because your Lordship on the last occasion indicated that inflow from the Brahmaputra waters are.
Maintaining the water table.
Yes, so
Maintaining the
Mr. Das is appearing for the water resource.
Learned Advocate General is there. He'll take care.
Yes.
Other than
Already
pollution
the
control.
water level has reached at the level of the road
Right now it is all right. What after the rains?
Winter, yes, that.
That is what the idea is.
Yes.
If you maintain it, the oxygen level is maintained by itself.
Yes.
That is, it's dependent on the volume of the water available.
And Malad, from the ground level, we'll file a reply once all the authorities have filed it. Then we'll give
There's
a.
jointly prepared list on 30th August at 4 p.m.
Malad, the
4 p.m., not
eco-sensitive
4:50.
part will also be brought up.
Everything.
God bless.
4 p.m.
For hearing, item 10.
14. Malad, if 14, I have some problem. Can it be beyond 14?
Which one?
30th.
30th August. We have.
Sorry.
It's a witness. 31st, fix both the matters on 31st at 3:30.
Lordship, this matter is relating to the various monuments under Ahom regime, Lordship.
Yes. Last date we had directed implement of the SI.
Yes, Lordship.
Madam, yes.
Lordship, our instructions are awaited, Lordship. Within a week.
ASI is already in the picture. What instructions are to be given?
As per last order, Lordship, regarding to obtain instruction regarding plan and proposal.
Plan and proposal.
Yes, Lordship. So regarding that, we have already communicated.
I have the detailed report, which are the monuments under protection of the Archaeological Society of India, etc. I received a detailed report from the Chief Secretary last night. I would like to file an affidavit. Let it also come on 30th.
30th. As jointly prepared list on 31st. We are listing them on 31st.
Lordship. The detailed
At
report is there.
3:30 p.m.
Right, we have identified all the monuments and which are under which authorities protection and preservation.
Deeply.
Item number 12.
Yes, Mr. Bukan.
May I please your lordship, my lord, I'm sorry I couldn't appear physically, my lord.
No, not an issue. Yes.
My lord, I wish to draw your lordship's attention to the last two orders. 26th July is the order, my lord, the last
Yes.
order.
Yes, yes.
By which your lordships have taken note of the submission that Gammon India was terminated and a new contractor was yet to be appointed.
Any new
for
contractors
completing-
coming? Mr. Saikia?
Lordship, on the last occasion, there is one area which was not covered and we have not covered in our affidavit also. That report also I have received. 1% is 100% over. The next, the second phase work has to start now, Lordship. That
Well, last date you said that Gammon India could not complete, so it's probably the contract has been terminated.
terminated.
What has happened after? Any new contractors come in?
Yeah, we have singled out one, whether it has been allotted or not, that information on 30th I'll give.
31st, as jointly period list on 31st.
The southeast
31st.
also.
You're not there on 30th, 31st?
30th.
31st.
30th, Lordship.
All right,
Deeply
then
obliged.
all matter on 30th.
30th.
30. Yes.
Deeply obliged, my lord.
Passed over matter 1 to 3.
Lordship, I have gone through the affidavit. We have very clearly stated here in page 106. What is there for Guwahati and other areas? For Guwahati, Lordship, there is a biomethanol plant of capacity 5 TPD at Satribari is functional. Then another, it has been proposed in Adabari of 60 TPD and one organic waste converter capacity to be is functional.
These can tackle organic waste. What about inorganic waste? Basically plastics. That is what the concern
We have to
is.
segregate it and the plant is taking care of both, Lordship.
Segregation, but how would the plastics would be disposed of?
Disposed of, Lordship, ultimately we have to, that plant is going on at page 109. 150 metric tons thing, Lordship. And so
for,
far as other is the compost plants are going on in various places, some are
we
functional.
understand, Mr. Saikia. Those plants would take care of the organic waste. Organic waste is otherwise also not a problem. It decays with time and it gets disintegrated. Problem is of inorganic waste.
The basic
main
plastic.
issue is plastic. For that, the suggestion is to come, maybe an incinerator based power generation or whatever. Because Singapore is doing it exclusively. Now it is importing plastic material, waste material. They burn it and then they generate electricity out of that. That is what the basic idea behind asking you to come out with a plan for solid waste disposal.
Lordship. Basically, organic, it is covered here.
Organic is all right. Organic is otherwise also it disintegrates with time.
Organic is only about shifting.
Yeah, organic is shifting and placing it properly. The problem is about inorganic waste.
Let me come up on 30th, Lordship.
30th. 30th, 330. Come out with a proper suggestion, we can incorporate it in the order. Execution will take time, but solid waste, unless you address the plastic, will never get by the issues which are being faced by us. And that is essential now, looking to this climate change and everything. And it really works well because you get electricity out of it. That means less fossil fuel to burn. Lot many advantages of that. Whatever the best way you can say, maybe recycling, that's one way to do it. But the answer has to be given by the state laws. Okay, all three.
May I please, Your Lordship?
Yes.
In item number 2, my Lord may kindly peruse the order dated 19/7/2022.
22.
Yes, 19/7/2022, my Lord.
Then item file number 2 then. There is one indication, Mr. Saikia, regarding there being some budget allocations under the Swachh Bharat mission. Maybe how to utilize that, the state can come out with some suggestion on that also. The DPR is given for the Sivsagar processing and treatment of legacy waste. But what these DPRs talk of segregation only. Ultimate disposal, that is what the requirement is. Let's come to this report, Swachh Bharat Mission, page 46. Saike, you have it? There's a report, this one, DPR.
Yes. Yes, Lordship, page number 6.
Page 46, 46.
Oh, here it is a diagram only, or maybe it is a.
No. This the chart. This is the report. Do we have 2 copies? Yes, we have an extra copy. Yeah, take this for a moment. 46. Right. This goes. Raw waste, manual shredders, size of waste for rescale, billing unit, combustible method, workflow is. Complaints, then again, you have a look at this chart and this report. We'll ask the registry to give you a copy. The registry shall provide a copy of the DPR. Who is representing the Sivsagar Municipal Board? Do you have placed this report on record probably?
No, it is placed by me.
You have got a copy?
Yes, we have copy, but right now.
So all right, we'll ask the registry to provide. They shall provide a copy of this report to the Advocate General. Yes, madam, you are referring to order dated?
19/7/2022, madam.
Yes.
Pursuant to the order dated 21/5/2022 passed by this court, Mr. R.K. Bora, learned additional senior government, Assam has placed an order dated 18/7/2022 passed by the additional deputy commissioner Sivsagar, which shows that a piece of land measuring so and so covered by general Sarkari Dag number so and so under Howrah Moja of Dimor Revenue Circle has been earmarked for the purpose of setting up solid waste management project subject to approval of SDLSC Sivsagar. By the order aforesaid dated 18/7/2022, the circle officer Dimor Revenue Circle has been directed to hand over advanced possession of the land concerned authority and to submit a report accordingly.
What happened thereafter? Land has been allotted or not? Allotted, thereafter the tender process is also referred to.
Yes.
So what are you trying to say?
Means our prayer is for shifting, my lord.
What has happened, Mr. Bora? After that? You have the tender part is
Tender
referred to
also-
in order dated
My
24th
lord,
November.
Initially, land was allotted, but it is again returned back because this is not feasible for my lord dumping ground. Initially, it was allotted. It is existing, my lord, dumping ground, the construction will go on.
But that is under question in this.
Yes, exactly. Yes.
Then whether there is any direction by this court to shift it.
I think there's no such.
Madam, is there any direction to shift the existing dumping ground?
Mr. Bora has submitted this tender notices.
Then he
and then-
says that, which is that later decision whereby that substitute plot has not been found suitable.
My lord, that has instruction, my lord, obtained from the deputy commissioner
They
right
have
now.
not submitted something.
You have not submitted anything. It's an oral instruction.
Affidavit we have filed, my lord, affidavit, lordship, filed by the director.
Have you
Municipal
mentioned it in the
Administration.
affidavit?
Yes, director
Let's see.
municipal administration. page
Which
20.
affidavit? There is no affidavit in this. Separate file.
Yes.
What is the date of your affidavit?
The 27 to 23
27 to 23.
by the director,
Hmm?
by the director of Municipal Administration Department.
Yes. What has been said in this?
Yeah, my lord, page 29, it is pertinent to mention here that Mission Directorate of Swachh Mission Assam invited expression interest from interest consultancy from firms, and accordingly 14 numbers of consultancy group participated, and later after due process for consultancy firms. This, my lord, everything has been completed. Only we are waiting for the financial approval.
What about the land? You say that the land which was identified as an alternative plot has not been found suitable.
Yes.
Where is that submission?
That submission, my lord, the separate land allotted or not, that instruction I don't have. Yes.
And come out with that instruction on 30th.
30th, lordship.
Mr. Bora, please for time. Please on 30th. Done.